just get some Google before BBC website.
Good morning. It's now 9:30 and the inquiry is open. I have nothing to add to what I said yesterday. There's nothing that needs to say. So let's get straight on to the planning evidence, and that's Sandra Ford and Ms Daly.
Thank you very much, sir. Good morning, Ms Ford. Oh.
Mr Kirby, Mr Kirby, reflecting upon what was said during the course of yesterday and also having reviewed his own proof, has produced a very short addendum in order to explain what he's going to say today. We have shared that with the council last night. As I understand it, my learned friend, having seen it, has no objection to its introduction. Would it be of assistance to provide that to you now?
Yes, it's not new evidence, is it?
It will be something that it's not new evidence as in new fact, it is effectively what Mr Kirby will say, and it's fair that the council know what Mr Kirby will say with regard to matters of weight and balance. So that's the reason why it was shared with the council in advance.
Okay. Ms Daly, have...
Yeah, I've seen it. I don't have any issue with
no
it.
issue yet. Good. Okay, that's fine. We'll now get on with the planning evidence.
Thanks very much. Good morning, Ms Ford.
Good morning.
Can I ask you please to turn up your proof of evidence at page 2, and just by means of introduction, you tell us that you have been a planning director at Marins since July of this year, that you've got a postgraduate diploma in town planning, a certificate in professional planning studies, both from the University of Central England in Birmingham, and a postgraduate certificate in urban design from Oxford Brookes University, and you're a member of the RTPI.
That's correct.
And you also tell us that you have over 23 years of experience of working in town planning, both in local and central government development management, strategic planning, regeneration and delivery, and more recently in the private sector, and that prior to your employment at Marins, you were Head of Development Services at Tewkesbury Borough Council, with responsibility for the Development Management Services Division.
That's correct, yes.
Good, and you tell us that in your current role, along with acting for the council in this inquiry, you're also acting for a number of developers and preparing applications for planning permissions and promoting a number of sites of varying sizes.
That's correct.
And you tell us that you've given evidence at a number of Section 78 and local plan inquiries, EIPs, and regional spatial strategy examinations on a range of town planning matters.
That's correct.
Good, and we can see your professional declaration at paragraph 1.5. Section 2 of your proof is a summary of your evidence. Section 3 is your introductory section, and you set out the scope of your evidence in the first couple of paragraphs on page 8. You say you address the overall planning balance and also the main issues identified by the inspector at the case management conference.
Correct.
Good, okay, and then section 4 of your proof deals with the legal and policy context. I just wanted to ask about, we won't go through all of it by any means, I just want to ask a couple of points. So, one thing that hasn't been discussed so far at the inquiry is the process for the Northampton Local Plan Part 2 and the approach that was taken to this site in that examination. Can you help please with what happened in relation to this site?
Yes, the site was put forward as a potential site to the council for inclusion within the Part 2 plan. The council, as part of its assessment of a number of sites that were put forward to it, I think a range of sort of 7 criteria that the council looked at. Those are set out within my proof, looking at the planning history, the deliverability, the constraints. And that the outcome of that, there was a sustainability appraisal that was undertaken as part of the local plan, and there was also a range of factors. And that concluded, those assessments concluded that there was a positive impact for the economic benefits of the site. However, there were a number of neutral benefits, but there were disbenefits in relation to the impact on the Great Houghton, the SPA. So therefore, it was concluded that the site was not suitable for allocation for employment within the plan. That was obviously discussed at the examination in public for the examination, and the ultimate result was that the site was not included within the local plan.
Good, thank you very much. And another point in relation to the legal and policy context, and this is something that you cover at paragraphs 4.18 to 22 of your proof, page 14 onwards, and it's the heritage policies in the joint core strategy and the Great Houghton Neighbourhood Development Plan and their consistency with the NPPF. So this is a response from you to a point I think you understood that Mr Kirby was going to be raising in relation to consistency of those policies with the NPPF, in the sense that those policies do not expressly include a requirement to balance public benefits against heritage harm. Just your view, please, as to, you've stated in your proof that you disagree with Mr Kirby's view, your view, please, as to the consistency of those policies with the NPPF.
Yes, certainly. I mean, certainly government guidance is very clear that development plans should be concise and to the point, and they should not repeat or replicate national guidance. So therefore, the fact that the policies do not include that specific criteria within their policies, in my view, that does not automatically say that they're out of date, because the NPPF is very clear that when you have heritage assets, then you do undertake the assessment of the public benefits assessment that needs to be undertaken. I think it's also important to stress that the JCS was adopted subsequent to the NPPF, which required that public benefits assessment to be undertaken, and also the local plan went through that process of examination at the end of last year and was found to be sound. So therefore, to say that it's not compliant with the NPPF, I do disagree with. And also the same process for the neighbourhood plan as well. You know, the process for a neighbourhood plan requires basic conditions to be met, and one of those conditions is around the in conformity with the strategic plans and other plans for the locality. So just because it's not set out in those specific policies, my view is very clear that the NPPF does require that to be undertaken. The policies have been tested robustly under the various processes quite recently, so therefore they carry full weight.
Thank you very much. And turning then, so we'll move away from legal and policy context matters. Section 5 of your proof, you deal with the main issues, and firstly you deal with the main issue of whether or not the site's appropriate for the proposed development, having regard to the policies of the development plan. So the principle of development point. Now the key policies that the inspector will need to consider in this regard are policy S4 of the joint core strategy and policy EC3 of the Northampton local plan part 2. Now you've set out in detail in your proof what those policies involve. Can I just ask you to summarise what you say an application needs to do in order to be consistent with those policies?
In relation to both policy S4 of the joint strategic plan and also policy EC3, they do allow development to come forward as long as they are in compliance with policies within the vision and objectives within the plans. So in essence, what applications have to do, they have to ensure they're in compliance with the other policies within the plan which relate to not only employment, but also heritage, conservation, good quality design. So it's the plan as a whole which those applications have to be in conformity with in order for those applications to be recommended and approved.
Thank you very much. Then turning to section 6 of your evidence, that's where you deal with the two reasons for refusal, the landscape and visual impact and the heritage impacts. And in both instances, you afford significant negative weight in the planning balance to the landscape and visual impacts and the heritage impacts. Now, you obviously drafted that evidence before you heard the oral evidence this week. I'd just like to understand whether your view has changed on the nature or scale of the adverse heritage or landscape impacts of the appeal proposal.
No, my view has not changed.
And in terms of weight, has your view changed?
No.
Okay, so it's the same sort of question in relation to section 7 of your evidence, which is where you deal with, amongst other matters, the employment and the economic considerations. And in relation to jobs, there's been an addendum to your proof of evidence. You set out in paras 7.3 to 7.7 of your main proof that you attributed moderate weight at that point to the provision of jobs based on some BRES data that was subsequently superseded the day after the proofs were exchanged, as was discussed by Mr. Robinson yesterday. And one can read in your addendum proof that you updated your assessment to attribute significant positive weight to the jobs that would be provided by the appeal scheme. Has your view changed in relation to that?
No.
And then in relation to land and demand, still in section 8, paras 7.8 to 7.16, you identify that there is a need for employment land to be delivered within the authority's area. You look at the emerging evidence base for the new local plan, and you also accept that there's a local demand for the development of the nature proposed. You've attributed that in your written evidence moderate positive weight. Can I ask if your view remains the same in relation to that weighting?
Yes, it does.
Okay, now what I'd like to do is turn to the public benefits of the appeal proposal, and I think the easiest way to do this, given that there are a few additional benefits that were put forward by Mr. Kirby in his proof, is to look at the table in his proof of evidence, which is at paragraph 8.5, page 79 of his evidence.
Yes, I've got it.
So the first one is jobs, and you've already provided your view as to jobs. The second one is he says the proposed development would result in a capital spending linked with the proposed scheme that could create additional direct and indirect GVA for each year of construction, and he's attributed that substantial weight. Now, just first of all, do you accept that the contribution, the economic benefits, the contribution to the economy of the appeal scheme should be accorded, should be considered as a benefit?
Yes.
And in terms of the weight, what weight would you attribute to that benefit?
I haven't set them out specifically, broken them down as Mr. Kirby has done within his proof. But in connection with the GVA, I would give that moderate weight, and the reason for doing that is twofold. First of all, as we were taken to yesterday, in relation to this core document reference A3.5, the environmental statement appendices in relation to the population paragraphs 5.530, 5.531 and 5.533, which assesses the new employment opportunities and the wider impacts. They have all been assessed in the environmental statement as minor beneficial. So that was the first thing that I looked at, because in connection with GVA, my understanding is that you can't do GVA on a local authority boundary. It's done on a wider geographical basis. And the other document...
Could you just remind what document this is?
Yeah, so this is the environmental statement appendices in relation to population. And so what that does, it gives an assessment in relation to the effect on the economies of the local and the wide impact of the area. That's under 5.530. Under paragraph 5.531, is the new employment opportunities. And that's on the effect on the labour markets of the local and the wider impacts. And 5.533, within that same document, it refers to the effect of new employment opportunities on deprivation in the local and the wider area. So the second document that I looked at to sort of understand the weighting that should be attributed was core document K32, and that's WNSP background paper. And in paragraph 3.1 of that zone, that's dated 2018. Sorry, thank you. That indicates that the value of the West Northampton economy, GVA, was around 11.5 billion. So that's the only information I've been able to look at. So therefore, acknowledging that the GVA of the scheme is approximately in the region of total 30 million, when I think there's some discounting that goes on, so that then looks at around sort of 20 million. So when I compared it to that 11.5 billion for the West North Hants, I would therefore assess that the GVA is moderate.
Thank you very much. Moving on then, the next benefit put forward by Mr Kirby is the commitment to provide funding towards training and apprenticeship opportunities that's set out in the Section 106 agreement. Your view firstly on whether that is a public benefit of the scheme?
It is a public benefit, however, it is something that's a requirement as part of the planning application. So again, I haven't referenced it specifically in my proof. However, because this is a requirement as part of the scheme, then I would therefore assess that as being neutral.
Thank you very much. The next benefit put forward is land, and that's something that the provision of employment land, that's something that we've already covered, that's in your proof of evidence. The next one is the delivery of off-site highway improvements, and Mr Kirby includes a list of those improvements that would be delivered by the appeal scheme. Is that a benefit in your view?
Sorry, the highways.
The highways, yeah.
Yes. It is a benefit, yes.
And what weight do you say should be attributed to it?
I attribute limited weight on the basis that the obviously the highway requirements are a requirement that's set out from the local highway authority. However, I do acknowledge that the provision of a new cycleway could be used by others that would not be travelling to and from the site. So that would be beneficial in terms of a highway safety. So therefore, I've given it limited weight because it is obviously above and beyond what's required for the actual application itself.
And then finally, the indicative biodiversity net gain, Mr Kirby attributes that moderate weight. Your view firstly as to whether it's a benefit, and then if it is, what weight it should be attributed?
Again, yes, it is a benefit to the scheme. I think we must recognise that this is an outline application, so I think in relation to the quantum of the biodiversity net gain, that will still be something to be determined. However, I agree that that should be given moderate weight in the planning balance.
Thank you very much. Then just going back to your proof, you deal with so moving away from the public benefits, I'd like to ask you about the heritage balance. That's something you deal with at 7.23 to 7.25 of your proof. Now, you've obviously indicated that you recognise that a few of the benefits put forward by Mr Kirby you do agree with, and you've given a view as to the weight that you think should be attributed to them. So I'm interested to understand, with that in mind, what's your updated view on whether or not the public benefits of the appeal proposal outweigh the significant heritage harm that you've identified?
Well, as we've heard at this inquiry, the information I rely on in relation to the heritage assets is from my colleague Adam Partington. Notably, we've got 2 Grade 2 star listed buildings. We also have 2 conservation areas which we acknowledge will be impacted upon. So we have 4 heritage assets. So therefore, in my opinion, that does carry significant weight in the planning balance. So my view is that even though there are benefits to the scheme, they do not outweigh the heritage balance. So therefore, in my view, the application should be dismissed.
And in relation to consistency, just before you get to the conclusion, you then deal with consistency with the development plan as a whole at paras 7.26 to 7.33 of your proof. Sorry, 7.31. You set out your view that the proposal isn't consistent with the development plan as a whole. Has that changed based on what you've heard this week?
No.
And finally, you set out that you don't consider that material... Fine, thank you. You don't consider that material considerations indicate that a decision should be taken otherwise than in accordance with the development plan. Has your view changed on that?
No.
Good, okay, thank you very much. I don't have any further questions for you.
Mr. Goatley.
Sir, thank you very much. Ms Ford, good morning.
Morning.
Ms Ford, few matters, if we may, in terms of your proof of evidence. I take it you also had Mr Kirby's assessment.
Yes, I did. Yes.
Updated assessment. We'll come to that in due course, but I just want to make sure that that was a matter which had found its way to you and was before you. With regard to one thing which is a curiosity, if I may, and that comes from the terms of the decision notice refusing permission, which I think is K1. K4, I beg your pardon. With regard to reason for refusal 2, do you have that?
Yes, I do, yes.
There is a reference there as a reason for refusal, which is the South Northamptonshire Local Plan, Part 2. And it was certain heritage policies within that. I think it's a matter of common consent that the site is not and never has been contained within South Northamptonshire.
That's correct.
Nature of when one's looking at providing reasons for refusal, there is a need for the reasons to be full, complete, precise, specific, and all policies in the development plan to be referred to. I have to say, I can't ever recall seeing in a decision notice that I've otherwise had to deal with citation of reasons for refusal in a development plan for an area that doesn't include the area covered by the appeal proposal. Can you assist me as to where, either within the statutory regime or elsewhere, the NPPF or any delegated legislation, where there is anything that provides for citation of policies in other development plans?
I'm not aware of any legislation that allows that to happen.
Is there anything in the NPPF, national policy, elsewhere, that indicates that's an approach that's appropriate?
Not as far as I'm aware, no.
Now, the fact that there is within Little Houghton, there may be listed buildings or a conservation area, i.e. designated heritage assets, which are in a different administrative area, and the consequence of which might need to be taken account of. I'm not going to raise any issue about that being a factor of consideration. The difficulty I have is seeking to import a development plan policy from another authority. That's the difficulty which I have as to how that is a matter which has any operative control or consideration in context of a development proposal in a different local planning authority area. Can you assist me as to where there's a justification for that?
I think in relation to the assets themselves in Little Houghton and the conservation area, when you view the site, I think as a planner, looking at things from a spatial perspective, you know, administrative boundaries, you know, are on a plan. When you go out on site and you look at areas, you don't think which location am I in, or which administration boundary that you're in. The view that I'm advocating is that from the site you can see Little Houghton, so therefore I think it is appropriate and reasonable for those policies which affect those assets to be a material consideration. I'm not saying they're part of the development plan. As you quite rightly point out, there's nothing within legislation, but I think they are a material consideration to be taken into account.
The difficulty in understanding how to take into account something which is not referable to this plan area. I understand within the statutory regime, designated heritage assets, whether it's a listed building or a conservation area, consideration has to be given to those.
Correct, yes.
The NPPF says that consideration has to be given to those.
Yes.
So I'm not suggesting that under those guise or headings there isn't a need to have regard to those, but those would be the basis to consider them, either under their own statutory status, yes, or
yes,
for that matter, having regard to the NPPF. The difficulty I have is where that imports as a consideration for one development plan administrative area, a development plan extraterritorially for another area, and over which inevitably there would not be any control.
My view is that because from the site that you can see those assets which have policies within acknowledging they're in from a different local authority administrative area, but I think it is reasonable to take those policies into account as a material consideration. I'm not saying they're part of the development plan, but I think they are a material consideration to be considered.
That would involve, wouldn't it, an inspector having to make deliberations about a development plan which is not the development plan which is operating on this particular development, isn't it?
I think, you know, it will be up to the inspector as to whether he wishes to use those policies as a material consideration or not.
The circumstances I've put to you, are there any other instances you can point to where the development plan policies referable to another local planning authority are in some way impactful on a decision within another local planning authority area in this sort of circumstance?
In relation to these particular circumstances, no, I'm not.
I'm going to invite you to consider that they are, as policies, irrelevant. Not that Little Houghton and its designated heritage assets are irrelevant for the reasons I've outlined, but that those policies within the South Northamptonshire Plan are irrelevant, and those should not be a matter of deliberation here.
I think, as I've set out, I think they are a material consideration, and I think that will be up to the inspector as to whether he wants to take that view or not.
Thank you. I'll deal with that in submissions. Thank you for your answers there. In context, if I may, your reference to the local plan part 2, the Northampton local plan part 2, and the SA assessment. Can you assist me? Was that assessment the subject of any specific heritage assessment, environmental assessment, or habitats regulations assessment?
In relation to the level of detail that the assessments went into, unfortunately, Inspector, I'm not able to assist because I wasn't involved in the local plan examination. So the level of detail that they went into, I'm not able to assist in that matter.
Because we've not seen anything, despite seeking such, nor is there anything, as I understand it, because the two principal reasons for discounting that site within context of its being put forward for allocation was, first of all, impact on the SPA. Now, as a matter of fact, that's not a matter which is in contest here, because the assessment of the site indicates that is not an issue, which means that the site is debarred from consideration. That's right, isn't it?
It is correct. Right.
Yeah.
Yeah.
So a process that said it was debarred from consideration by reason of the SPA, or indeed should be considered unsatisfactory and not appropriate for allocation, that's no longer been found correct by means of that assessment. Would you agree?
I would agree for the SPA, yes, and I think just a caveat that, you know, when you're dealing with a local plan, when I would not expect for each allocation to go through a very fine detailed assessment. That is not the purpose of a local plan. A local plan will have a very high level assessments to be undertaken on sites coming forward. So that's my experience when I have overseen local plan preparation, and it's when you get to the finer detail of a planning application, that's when you would have very detailed assessments to address the finer details and impacts of a particular development.
I would understand that if one was dealing with a criteria-based exercise, which actually put that as being a criterion or criteria for consideration when proposals came forward. But in circumstances where what the plan was doing was engaging in a process of rejecting sites from consideration for allocation without doing that exercise, that becomes problematic, doesn't it? If it turns out that the information upon which it relies is not actually without flaw.
I wouldn't necessarily agree with that, because I think the local plan, you know, the evidence base that you go through for a local plan is at a much higher level, because you're dealing with a whole plan. So therefore, when you deal with individual site allocations, it is a high level assessment that will be taken forward.
And we know, don't we, that so far as the planning committee report, the officers' report in consideration of matters relating to the conservation area, that the officers of this council did not consider that there would be a significant impact on the conservation area at Great Houghton. That's correct, isn't it?
It is correct, yes.
Yeah. So in that regard as well, the other principal ground upon which the site was not identified for allocation, and that's a separate issue as to whether or not, irrespective of its allocation, whether that feature should be the subject of further assessment by reason of criteria. that wasn't a matter which the council's officers considered was justified. So the two principal grounds, neither of which were considered justified by the council's officers during the course of this application.
That's correct.
So the absence of an allocation within the plan, having regard to those matters, is, to put it at its lowest, far from determinative. Would you agree?
I think the absence of the allocation demonstrates that, you know, at the time of the examination, that there were insufficient grounds to actually put the site forward. You know, the council have got other sites that have been allocated for employment use, and I think it's notable that the policy EC3 was amended during the course of the inquiry as part of the main modifications, in order to allow windfall sites to come forward, so that if sites were in compliance with other policies within the plan, then permission could be granted.
Yeah, indeed, and we'll come back to EC3 and just that point in due course. But what I'm dealing with is the process, in fact, to reject it from allocation was by reason of an insufficiency of justification for its rejection, rather than an insufficiency of evidence to justify it. Would you agree?
I haven't seen all the evidence that was put forward as part of the examination, so I'm unable to answer that question.
Okay. With me for a minute. Now, the policies dealing with designated heritage assets that have been referred to, those include, I think, the following, which are BN5 of the core strategy, and as far as the neighbourhood plan are concerned, policies 1, 2 and 6. Are there others relating to heritage that we need to consider?
Just bear with me. I believe there is a policy, and I'm trying to find the reference number within the local plan as well, so just bear with me.
Not at all. Beg your pardon, it should be ENV6.
Thank you, that's
That's
one
my
I was just trying to find in the local plan. If we include that one as well, then yes, that would
Yeah.
cover all of those.
Okay, let's look at that set. First of all, if we may, in respect of BN5, this is of the joint core strategy. I think you have yourself identified that, but in terms of relevant extracts, I think you're at K11.
So I think you do have a copy of the whole plan, some which might be easier to look at. Yeah.
BN5 is at page 121, internally numbered, or the PDF is 3149.
That's all right, fine.
Do you have that available to you?
I do, yes.
Thank you very much. Doubtless a policy with which you are familiar. Is there anything within BN5 which replicates the public benefits test contained within the NPPF paragraphs relating to the consideration of proposals affecting designated heritage assets?
No.
And that issue relating to designated heritage assets, that relates whether it's a substantial or less than substantial impact. That's correct, isn't it?
Yes.
So it's fair to observe there isn't, if I can put it this way for this purpose, there is an inconsistency and an absence of that factor within BN5.
It's not included within BN5, however, because it is within the NPPF, then I would argue that policies should not be repeating or replicating the NPPF. So from my experience of working for councils, is a constant mantra from the government not to repeat government guidance.
Right. In which case, why do you need BN5 at all, given that you've got a policy within the NPPF that tells you how to deal with impacts upon designated heritage assets? You don't need it at all, do you?
Yeah, the policies that we have,
No,
yes you do.
No, forgive me. Why do you need it if it replicates what's in the NPPF? Just adopting your argument. Why do you need to have it, given that you've got the policies which are at paragraphs 199, 200, 201, 202 of the NPPF? Why do you need to have BN5?
Policies which are developed for all local authorities are very much to deal with their sort of individual sort of circumstances. Where you have something which is as generic as assessing that public benefit, then there is no need for that. But I would expect councils to have policies because they are of a more of a localised nature.
Is there anything in the NPPF that indicates that something of a localised nature means that you are able to replicate some bits of policy but not other bits of policy?
No, the NPPF is not drafted in such a way.
No. So the NPPF intends, does it not, that if one is to be consistent with it, if one has a feature that says, don't do X unless you do Y, you can't just put in the don't do X unless you put in the second bit, because then there would be an inconsistency and non-conformity with the national policy because it's deliberately expressed and formulated in that way. That's fair, isn't it?
I don't think it is. I think the NPPF sets out a framework across all of exactly that. It's a national framework. So, individual councils take their policies to a finer level of detail, and there are certain elements of the NPPF which don't need to be replicated because that they apply to all councils. And I do take the point that, yes, you could say, well, actually, why do you need any policies? But, it is around that individual and that localised factor that we have policies.
What's the localised factor that means that the countervailing consideration of public benefits should be excluded from West Northamptonshire as opposed to any other part of the country?
I'm sorry, could you
Yes, what is it that's the individual or localised feature that means that the consideration of public benefits does not fall for consideration on heritage matters in West Northamptonshire? What is it that's the local feature that makes that feature good?
It's not the localised feature isn't the fact that you apply the public benefit, it's that the localised feature of the policy relates to the specific issues that are are applicable to Northampton. So for example, the policy BN5 refers to the battlefields, the ridge and furrow. That's the sort of thing that I would say that is different to, I wouldn't expect, for example, to find ridge and furrow within authorities that worked in the past which are quite urban. So I think the policies that are put there are to make sure it's reflective of that local area.
Right. Where within the West Northamptonshire JCS local plan do you find, for the purposes of balancing heritage harm, if there be any, with public benefits, purely within the development plan policies?
As far as I'm aware, it's not there.
So if one's looking at the test of applying that policy, first of all, there is no place for those public benefits to appear within policy. Correct?
No, because it's set out within the framework.
The framework is not part of the development plan, is it?
It's not part of the council's development plan. However, by default, the national planning framework is something that has to be taken into account in the determination of applications.
The reason why the NPPF is set up in the way that it is, it's whether or not, do you have the NPPF
I do,
available to you?
yes.
Can you have a look at paragraph 219? It's within the annex, Annex 1. And this is trying to work out whether policies are up to date or out of date or not. And the purpose for this exercise is whether or not there is consistency or not. Now, so far as the development plan is concerned, so far as BN5, it is inconsistent with the NPPF in not providing for that public balance weight. Would you agree?
No, I don't agree.
So we have agreed that the public balance weight is a feature of national policy in the NPPF.
Yes?
We've also agreed that there is nowhere in the JCS, including BN5, for that public benefit to be taken account of.
Correct.
You say that that is, in which case, that circumstance of not taking account of public benefit within the JCS, are you saying that is consistent with the NPPF?
Yes, I am.
Okay, I'm going to leave that matter for the inspector to deal with, because I'm going to give you one further opportunity, because that is palpably illogical, isn't it?
No.
Because there is no other means within that policy to deal with the public benefit, is there?
By direct relation to the NPPF, which clearly sets out that benefit.
Right. Where within the development plan does it say the policy is to be applied within the NPPF as part of the development plan policy?
In my view, it doesn't have to say, because it will have gone through a process when the JCS was being examined. Part of that process is for the examining inspector or inspectors, I don't know who there were, one or two at that time for the JCS, to ensure that the policies within the plan are in accordance with the NPPF.
Yeah, well,
So it's that process that will have gone through, and to make sure that it's sound. So if it wasn't if there were policies in the plan which weren't in accordance with the NPPF, then the plan would not have been recommended, well, as sound or adopted.
I have no reason to understand what, if anything, was before the inspectors and whether or not that was in their mind when they were dealing with the matter. We do know that the joint core strategy was adopted, and we see its terms. I'm not going to be retro-critical of this, but the simple fact is that there is nothing within that policy or within the JCS which provides for that particular exercise of weighing benefits to be undertaken. Correct?
Correct.
Yeah. You don't make that position legally sound other than the fact that you have a plan which is adopted having been declared sound. That doesn't make it legally consistent simply by saying it's gone through a process, does it?
But it has followed due process.
Yeah. If one comes to scrutinise it, if you have a decision taker later asked to consider whether that is consistent or not, and that is simply signed off on the basis of what went in the plan before, that later decision taker would have failed to grapple with the issue of inconsistency, wouldn't it?
I don't agree with that.
Okay, in which case I'll leave that as a matter for submissions, but I will highlight the illogicality of the approach which you have adopted. The terms, please, of the neighbourhood plan. And I think this is K12. I don't know whether you've got a copy of the neighbourhood plan there, so what?
It's in the folder.
It's in a folder, yeah.
I'm afraid mine's not, my list isn't subdivided to know which folder it's in. It's K12, sir.
It's like folder 5F.
I'm grateful.
Was it F or S?
F for Freddie. Oh, right. I got that right?
Yes, F.
I have it now, yeah.
Dealing first of all with Policy 1, protecting village character and rural environment. This is a siting policy. So far as that policy GH NDP 1 is concerned, what part of it indicates that there must be a rejection of this proposal?
Criteria B refers to be of any schemes, proposals should be of a high quality design and must take into account and be sensitive to the significance of the setting of the Great Houghton Conservation Area evident through a heritage impact assessment. Criteria C also refers to the sympathetic surrounding rural landscape and sensitive to Great Houghton. And the A is around the separation for the area.
Right, okay, so we've got essentially A, B and C to deal with.
Yes.
Yeah. Separation by retaining the green buffer. Does this intrude on the green buffer?
The actual neighbourhood policy itself does include a green buffer which is contained within the neighbourhood plan. The appeal site does not form part of a green buffer denoted within the neighbourhood plan.
Right, so it'd be fair to say there's no conflict with A, is there? Because the green buffer will be retained irrespective of the outcome of this appeal.
On that particular, the site of the green buffer, that's identified correct, yes.
Yeah, I don't understand there to be any other separation that's identified. And the reason being is because it's to provide a clear separation between the development site and Great Houghton by retaining the green buffer area.
Yes, I accept that. Yeah.
Yeah. So A doesn't need to trouble us.
Correct.
Thank you. B, high quality design. First, I don't think design is an issue in play between us.
No, because it's an outline.
Yeah. Take into account and be sensitive to the significance and setting of the Great Houghton Conservation Area, evident through a heritage impact assessment. Well, there was a heritage impact assessment by reason of the ES. Yes.
That's correct. Yes.
Yeah. And sensitive to the significance and the setting. That doesn't say that there must be no impact. Simply, it has to be sensitive to. Correct?
That's correct. Sensitive to and the significance of the setting. Yes.
Yeah. So that doesn't preclude development, even if development were to cause harm.
That's correct. Yes.
Yeah. So B doesn't trouble us either, does it?
It has to. It has to be taken into account.
Indeed. And it was by your
course.
officers and is
Yes.
by the inspector. But that's a process point rather than necessarily indicating a particular threshold point.
Yes.
Yeah. So that doesn't trouble us for the purposes of this exercise because we are doing that.
Yes.
Yeah. Thank you. C, take into consideration and be sympathetic to the surrounding rural landscape and sensitive to the existing small-scale residential development within Great Houghton. Again, that's a similar process point to B above, isn't it?
It is a process point that has to be taken into account. Yes, in determination.
So there is no conflict, is there, with Policy 1?
There is conflict because, as we've just gone through, you have to go through a process. So if you find that via the looking at the development, you find as part of that process which you go through, you find that there is an impact on the significance of the conservation area, which was demonstrated by my colleague through the heritage impact assessment which you undertook. If you find that there are issues with that, then obviously that's a criteria that then if you find there is harm, which the council's position is that there is, then we do have a conflict with that policy.
There is no, that which you've just outlined doesn't appear anywhere within that policy, because B says it must take into account, so it's a process point, and be sensitive to the significance. Doesn't say there shouldn't be harm, or how you weigh that harm, or how you deal with that harm, just simply says you have to be sensitive.
But I think before you get to A, the very start of the policy, you say it refers to retain the character and identity of Great Houghton Village and the rural character of the area. Planning proposals should, and then it lists that criteria. So if you have anything within that criteria, which then is in conflict with those, then obviously proposals shouldn't be allowed.
No, that would be a completely unacceptable interpretation of that policy, I would suggest, as a matter of law, because it requires the interpolation of a vast number of points. It's a policy that asks for things to be considered. It doesn't say what the output of that consideration is. Because, for instance, with B, it would be open to a decision taker to take the view that, yes, I take it into account, yes, I am sensitive to the significance and setting, yes, there will be impacts, but I'm content with those impacts. Doesn't say there'll be no impacts, doesn't say what the magnitude of those impacts are.
Yes, but then there is an assessment, like I said, whether that involves an assessment to be made as to what the impact is and whether that's... So there is a policy.
Yeah. Okay, well, that's a matter for submissions again. But I hear your approach. Move on to policy 2. To retain the character and identity, beg your pardon, so I haven't given you the page number for that within the it's page 24. Planning proposals should have regard to the Great Houghton Conservation Area appraisal. So, first point is to have regard to. Doesn't say that it has to simply follow. Yes?
Yes.
Will be assessed against the following. A, not relevant.
Correct.
B, not relevant.
Correct.
C, not relevant.
Correct.
D, is that relevant?
No, it's not relevant.
E, not relevant.
Correct.
F, not relevant.
Correct.
G, buildings of local importance and other non-designated heritage assets. Buildings of local importance in the conservation area and other non-designated heritage assets don't form part of the reason for refusal, do they?
This policy was referred to in the reasons for refusal.
No, forgive me. G, which there were no buildings of local importance been identified by Mr. Partington, have there?
No, that's correct.
Nor any other non-designated heritage assets.
Correct.
So G doesn't impact on the consideration of this proposal. Would you agree?
I just want to make sure I'm reading the explanatory text as well, so if that's okay. Just to
Please
make
do.
sure.
Well, remember that any text beyond can't alter what's in the policy.
I accept that, sir.
Right. So policy 2 is one that just falls out of account entirely. Would you agree?
Yes, I would, sir.
Thank you very much. Now, let's forward. One other policy I think does fall for consideration when we're looking at the neighbourhood plan, but it's actually under reason for refusal 1 rather than 2. But rather than to go back through the exercise of running the plan, can I invite you also to look at policy 3 as well? Sustainable design and construction. Recognise this is not a heritage issue, this is a landscape issue of some reason, or a spatial issue. As far as policy 3 is concerned, so far as the first sentence is concerned, because it's outlined, I take it that's not engaged.
Because it's what, sorry, sir?
All new development should be sympathetic to local design features.
Yes.
Is that something that needs to trouble us now?
Well, yes, it should, but it is a new development.
Right. So it's new development, sympathetic. So matter for the inspector on an outline proposal to decide whether the development is sympathetic to local design features.
Yes.
Do you have anything to say as to where it is not sympathetic to local design features?
No, because it's an outline at this moment, sir.
So in one sense, from that point of view, it doesn't need to trouble us for the
Correct.
purposes of consideration
Yes.
here. Thank you. Second paragraph, development will not be supported where it's a poor design and has an adverse impact on the character of the area. Do I take it that doesn't need to trouble us either?
In relation to the actual design per se, because we haven't got, it's an outline, however, the actual sort of, an outline application which obviously develops in principle a location of a building, then I think it has to be taken into account in determination of the application.
Right. And do you have anything to say as to the development being of poor design?
In relation to the design, no, because it's an outline application.
So you're not saying that the poor design will give rise to an adverse impact on the character of the area?
The designer, but the actual sort of the principle of a building, then yes, would.
But it's not dealing with the principle of a building, is it? It's dealing with poor design. That's the wording that's used. It's not my drafting, this is someone else's.
Yeah, I think it is the issue that, you know, we haven't got details of the design because it's at outline. However, I would interpret that the principle of a building in a location that would have an impact on the, because going back to the all new development should be sympathetic to local design features. We've agreed the actual design, we haven't got that. But development will not be supported. So development, in my view, constitutes sort of, you know, the principle of development as well. Will not be supported if it has an adverse impact on the character of an area.
You're having to interpolate, and the problem with that is you are altering the interpretation of the policy because it is directed to poor design, isn't it?
It is referring to design.
So it's not a question of whether it's development or not, it's only a question whether it's of poor design. If it's considered to be of good design or of neutral design, then in those circumstances that would not engage the policy, would it?
Well again, I think it's where we have to, because the proposal around development will not be supported.
No.
So I would argue that does.
Forgive me. You have to read that entire sentence together, because otherwise you are seeking to drive the inspector into error on interpretation. It doesn't say development will not be supported. It says development will not be supported where it is of poor design. We're agreed that design is not an issue, and you do not assert that what's engaged here, or what's proposed here, is poor design. We're agreed on that, aren't we?
We are agreed because it's an outline application, correct?
So consequently, this sentence is not engaged because you don't say that there'll be an adverse impact on the character of the area by reason of poor design.
By poor design, no, but in relation to the principle of development.
Yeah, it doesn't say principle of development, does it?
No, it doesn't.
No. So read the words as they are. Development will be not supported where it is of poor design. That has an adverse impact on the character of the area. You don't say that it's poor design that has an adverse impact on the character of the area. If it doesn't say that, then in which case you can't say anything about support, can you?
I accept the inclination that the design of a building, no, I cannot.
And it doesn't say anything about the principle of development at all, does it?
It doesn't specifically refer to the principle of development. However, the title is around design and construction, and we should be, all developments should be sympathetic to local design features.
No, but forgive me, either you're going to deal with this on design or you're not going to deal with it on design. It says nothing about principle, and there's nothing even in the explanatory text that talks about principle, is there?
No, there isn't, no.
No. Can I invite you to accept that in respect of this policy, so far as paragraph 2, it's not engaged, is it?
Insofar as the policy does not specifically relate to any principle of development, and it just refers to design, then I would agree.
Yeah, but it doesn't, so it's not engaged, is it? Has to be either it's engaged or not engaged. I didn't draft it, someone else did.
Sorry, can I just be clear? Are you asking about that sentence, the second paragraph only, or the policy as a whole?
Well, I'll come back to that in a moment. As far as this particular sentence is concerned, it's not, that is not engaged, is it? That second sentence.
apologies, I think I've been reading this as well, sorry. So in connection, when we talk about the second element, we're talking about the development will not be supported where it's approved design. And as I've outlined, the policy does not refer to the principle, just the design.
So the second sentence is not engaged, is it, by consideration of this proposal?
I'm going through all the criteria, sir.
No, come back to that in a moment. Just dealing with the second sentence.
I think I understand the points being made. I mean, that sentence I think has got to be read as a whole. So, development will not be supported where it is of poor design that has an adverse impact on the character of the area. I would read that unless you know what the design of the building looks like. You can't move on to the second bit about whether it has an adverse impact on the character of the area. That's how I would interpret it. If it was interpreted as more of a principle, there would be an and where instead of a that.
I would accept that, sir.
Thank you very much. Moving on to the third sentence, to ensure good design is achieved, development should be designed to take account of and will be assessed against the following criteria. All of those criteria, ultimately if they're designed, those are essentially going to relate to the future design that comes forward. Would you agree?
Having the clarity of going through that, yeah, I would agree, yes.
Yeah. So, as far as policy 3 is concerned, that doesn't tell against this particular development and is not a reason or is not a justification to refuse it. Would you agree?
In relation to the principle, I would have to agree, yes.
Thank you very much. Policy 6, which is on page 36. New development should conserve or enhance the local landscape by A. Respecting and enhancing the landscape setting, landscape features, field and settlement pattern of the neighbourhood area. You saying that we're in conflict with that?
Yes.
Okay. So I'll come back to these when we've worked out which ones we need to deal with. Alternatively, can you tell me, okay, B, having regard to the scale of any harm or loss and significance of the heritage asset, seeking to conserve in situ or by record heritage assets of archaeological value, including ridge and furrow, that's a seeking to conserve in situ policy or record. Would you agree?
Yes.
That doesn't need to trouble us. Would you agree?
Yes.
Okay. Thank you. C. Don't think that needs to trouble us, does it?
I think, yes, it does.
Well, we've got BNG, we've got a condition dealing with a landscaping scheme. Retaining or enhancing ponds, any issue there?
No.
Streams,
No.
mature trees,
No.
woodland and ancient and mature hedgerows.
I think it's just issue around the hedgerows which were referred to, and I think it was where we discussed with the evidence around the removal of the hedgerow or the self-seed. I think we for the access to the actual sort of site itself. There said that there is some impact there.
Yeah, but we have the or that comes later on, where removal is unavoidable, providing by way of offsetting replacement habitat elsewhere on site or within the neighbourhood plan area. Not only is that being provided, more's being put there than was there to start with.
I accept that.
So C doesn't need to trouble us, does it?
Correct.
Yeah. D, new planting and landscaping should use native and other suitable species and be designed in such a way to ensure that it's suitable when considering the local landscape and provide stepping stones or links to existing woodlands and hedgerows. We've obviously heard from Mr Jackson, but in any event, that's a scheme in futuro secured by condition, yes?
It is, however, I think it's worth of note that I think in my colleague's evidence, Mr Wadsworth, that he has raised the fact that some of the mitigation that has been suggested was not native to the site, so I think there's just that one issue there.
Actually, I didn't understand why that was non-native, because it's a future scheme. So all of the planting would be controlled by condition to ensure it's native.
Yes, it would. However, I think from the discussions that were held, Mr Wadsworth did raise concern of the part of the mitigation that was proposed as part of the landscaping scheme was not what he'd expect within that particular locality.
Well, whatever he expects, that's an illustrative landscape scheme. That would be landscaping to be determined through reserved matters approval, wouldn't it?
Yes, it would.
So in which case D doesn't need to trouble us, does it? Because that can be controlled. You'd still apply D to the reserved matters application.
Yes, you would still apply that to reserve matters, but I'm just making that point that he has got
but
concerns.
it's not a matter that needs to concern us here. Thank you. D doesn't concern us.
Correct.
F, seek to minimise the encroachment of development into visually exposed landscapes. Where development is proposed on the edge of the village, it enhances views of the settlement edge from surrounding countryside and does not lead to inappropriate incursion into surrounding countryside by reason of siting, design, materials or use of landscaping. That, I take it, is a matter that you do consider as engaged.
I do.
Come back to that one. Maintaining and where practical improving access to the surrounding countryside. I think don't think there's any issue on that one.
Correct.
Yeah. H, seeking to conserve and enhance the integrity and fabric of historic buildings and their settings. Last bit, it seems to be settings. That's going to be a matter you'll want to come back to.
Yes.
Okay, so what we're left with is A, F and H. I'm going to take H first of all. Seeking to conserve and enhance doesn't require conservation or enhancement, it's a seeking. Yes?
Yes.
Integrity and fabric of historic buildings, that's a different issue. That's not a matter in play here. Would you agree?
But it's the second one and their settings.
Settings, I'm going to come back to settings, but so far as the first bit is
fabric,
relating to...
correct.
Yeah. It's a seek to do so, and in seeking to do so, it doesn't say that development that doesn't do so will be rejected.
Again, the start of the paragraph states new development should conserve or enhance the local landscape by. So therefore, because it is a policy which basically requires you to do certain things, and if you don't do those, then by default, then they shouldn't be allowed.
No, it just simply says that the way that you conserve or enhance the local landscape is the landscape policy is by, and the by is to seek, as far as is relevant to heritage issues, is by seeking to conserve and enhance settings. Well, I'm just going to interpolate heritage assets for these purposes. It doesn't say that there should be no harm, nor does it say how you should do so, because it's a seeking to, it's a process for future consideration, not saying how you actually consider them. Because, for instance, on seeking to conserve the settings, you may find, for the sake of argument, that there's actually quite significant harm. But for whatever reason, the decision maker decides that the new development would be conserved or enhanced. The local landscape would still be conserved or enhanced. Yes?
Yes, however, I think the policy is quite clear in connection with the overall direction of the policy is to make sure that the settings, should be enhanced and conserved. So I think it's very clear that the integrity of that policy, the direction of travel of that policy.
And remember, policies aren't directions of travel. Policies are contained in a legal document, and so being a legal document, it has to be interpreted in accordance with its terms, doesn't it?
It does, yes.
Yeah. And in these circumstances, it's a landscape policy, and so far as insofar as new development should conserve or enhance the local landscape, the reference within H that's relevant there is seeking to conserve or enhance. Sorry, to conserve and enhance. Doesn't say they must be, because they've actually deliberately repeated the terminology, but done so prefaced by the word seeking to. That's correct, isn't it?
It is, yes.
Yeah. And those words seeking to must be given purpose and effect, mustn't they?
Yes.
What it doesn't do is dictate what will be the test for consideration. Would you agree?
I think the test of consideration, though, is the fact that it's about the settings of those buildings.
But it doesn't say what you have to do with them. It says you seek to conserve. And indeed, insofar as it provides any suggestion, it's about effectively styles and use of materials. But it doesn't as such, does it, indicate how you would actually do so. It doesn't say what test is to be applied or what would be the outcome of that test. That's right, isn't it?
But the test...
Forgive me, if you can deal with the question I put, doesn't do any of those things, does it?
No, it does not.
No. So if one applies the policy, properly interpreted in its own terms, then it doesn't give rise to a need to determine conflict. That is correct, isn't it?
I don't accept that.
Right, well, where are the words? They're not my words, these are the words of the person who drafted it, and they have to be interpreted properly in accordance with their terms, not the words that might be introduced conveniently at some later stage. They have to be the words which are there. And if the words are not there, you can't just simply put them in, can you?
Yeah, but the start of the policy is new development should conserve and enhance the local landscape by, and it does say, seek to conserve and the building and their settings. So it doesn't set out how it does that, but that's part of any assessment. But when you've got a planning application that is submitted, part of that assessment is then looking at how do you conserve and enhance that, and how you seek to do so. There is a process that has to be gone through.
So it provides the fact that this is a factor that needs to be considered for the purposes of landscape conservation, not for heritage. This is not a heritage policy, is it?
But it does refer to historic buildings and their settings.
Forgive me, it's not a heritage policy,
No,
is it?
it's not. No.
So it's in the context of being a recreation policy, but in context of that recreational policy, what it's then saying, from that point of view, is that's how you seek to conserve their settings. It doesn't actually say what happens if their settings are in any way affected, does it? It doesn't provide a route map, it provides effectively a marker that the conservation to conserve and enhance is something that you would seek to do to conserve and enhance the local landscape.
The policy does not say that applications will be refused, no. However, what it does do, it sets out that for the decision maker, then they have to take into account that the new development should conserve and enhance the local landscape by seeking to. So there is a process that has to be gone through for that determination of that planning application.
Yeah. But it doesn't tell you how to do it.
No.
Nor does it suggest there's a presumption against or anything of that nature.
No.
Thank you very much. Thank you. I think that's everything within the NV6, if we may, which is of the local plan part 2, I think, isn't it? The local plan. Local plan part 2. It's K13, K14. I have this, it's page 110. I think, do you have that for you?
I do, yes.
Thank you very much. Protection and enhancements of designated and non-designated heritage assets. Council will require development proposals to conserve and enhance the historic environment and designated and non-designated assets, including the historic landscape, by 1. Ensuring development proposals demonstrate a clear understanding of the significance of the assets, the setting, and the impact the scheme will have on that significance. That's been done, and then maybe the officers agreed with the appellants, and we obviously know where we are with this appeal, but that's not an issue in play. Secondly, ensuring some enhanced understanding has been considered and incorporated into the development proposal, demonstrating how the scheme preserves and or enhances the asset. That again, same point. Do you agree?
Yeah.
Thirdly, requiring a clear and convincing justification of any harm or loss of an asset, supported by demonstrating how the harm is outweighed by public benefits. That's the balance test, isn't it?
It is, yes.
Supporting high quality proposals. I don't think that's a matter that's troubling us here, is it? 4.
I think the only issue here would be around the scale and the massing, because obviously this is an outline application, so we haven't got all of the finer details. However, I think certainly citing scale massing is something that needs to be taken into account.
Okay. I don't think scale and massing were part of the reason for refusal. Is that fair?
That is fair. However, it's the policies relating to the impact on the heritage assets. They were reasons for refusal.
And so far as your proof is concerned, I don't think you deal with scale and massing, do you?
No, I don't. No. Again, it's because of the actual principle of development.
Okay. So that's not a matter upon which you've actually advanced any case, have you?
I think only insofar as the principle of development.
Okay. Well, we'll leave that with the inspector. Having regard, okay, item 5, having regard to guidance from Historic England and heritage best practice. I don't think there's an issue in play there, is there?
Insofar from the evidence that my colleague Mr Partington gave.
Yeah, there's having regard to.
Yeah.
I don't think there's any doubt
No.
regard has been had to that.
Correct.
Now, what we do have is we've got a balance point in ENV6, haven't we?
Yes.
So, insofar as the inspector is dealing with any heritage harm and applying ENV6 criterion 3, he would be entitled to find that whether or not it's harm to which either negligible or limited or moderate weight is applied, whatever be the relevant view, he could nonetheless conclude that there's a clear and convincing justification.
Yes.
Yeah. That balance point, that is missing, isn't it, when to BN5?
As we've all discussed, that it's not, that particular criteria is not included within policy BN5, as we've already discussed.
If there is a conflict between BN5 and ENV6, which is contained in the last adopted policy, last adopted plan before the inspector. Tell me if you are aware of this, section 38.5 of the Planning Compulsory Purchase Act says you go with that which is the most recently adopted policies if there's a conflict. Are you aware of that provision?
There are so many provisions, I would have to look that one up, I have to say so.
Because I'll raise the point, but I'm not going to cross-examine you on it. If I'm right on that, and I'll just do it on basis of premise on basis that I'm right, in those circumstances the inspector will be entitled to apply ENV6 and Criterion 3 as the most up-to-date of all the suite of plans that are before him. Yes?
Based on a theoretical, that we agree that BN5 is out of date, which as we have discussed previously, that's not my opinion, but theoretically, if we're on that basis, I'll be guided by, as I said, 38, the section referred to, if that's what it says, and then this is the most up-to-date policy, that will be correct. But that's caveated, my response is based on a theoretical question.
Yeah, I understand that.
Mr. Goatley, it's 11 o'clock. I'd like to take a break at some stage when it's convenient to you.
So, thank you. That will be, I think, very, very shortly, because that's dealt with the policy section, I think, in respect of that. Just to tail that point off, if the inspector is in that position, then he would be entitled, wouldn't he, having carried out that balance within policy under ENV6, that if he were to find that clear and convincing justification occurred, that the development, so far as the heritage aspects are concerned, is in conformity with the development plan. Would you agree?
I'm sorry, could you repeat that for me, please?
Certainly. The inspector having the development plan before him, if there is a conflict between policies in the development plan, but he has the benefit of the most up-to-date policy, ENV6, which allows him to carry out the NPPF balance of harm and public benefit within development plan policy, then if he were to come to a positive conclusion on that, then he would be entitled to find that there was accord with the development plan on that aspect. Would you agree? That he would have carried out the balance in accordance with the development plan policy, and having done so, and having regard to which is the most up-to-date policy on that point, could then conclude that on the heritage issue there is accord.
On the heritage, but as you know, the public benefit is to do with all of the plan.
It is. But he could, okay, let me just break that down, in which case we'll bundle it up. If he comes to the view, notwithstanding everything that the council has said, including with regard to heritage, he could find accord with the development plan as a whole, because he could carry out the heritage balance under ENV6 Criterion 3, the most up-to-date policy.
Yes, he could, yes.
Thank you very much. That tells us the policy part. Thank you.
Thank you, Mr. Goatley. We will have a break now. It's, I think, 11:05, so if we break until 11:20, and I'd remind you, Ms. Wood, that you can't talk to your side at this stage. Thank you.
I allowed to get Sandra tea?
Yes, absolutely. Yeah.
Do you want tea? Sugar?
No sugar.
Great.
Very British idea for Persia.
Good morning again. It's now 20 past and the inquiry is resumed. Mr Goatley.
Thank you very much. Sword, I omitted when I'm dealing with the policy elements relating to policy 6 of the neighbourhood plan to go back to 2 matters which we had parked when dealing with heritage issues in respect of criterion H. So can I ask you please to go back to the neighbourhood plan?
Sorry, could you give me the sorry.
Yes,
Could
I
you
think
give
it's
me the
K. I
reference
think it
again?
should be K12. And if you've got the PDF version, it should be on page 12 or 16. Having parked them, I then didn't unpark them, so I need to give you the opportunity to deal with them. Items A and F, which we have organised. Our first one is on conserving or enhancing the local landscape by respecting and enhancing landscape setting, landscape features, field and settlement pattern of the neighbourhood area. That's not intended to preclude development, would you agree?
Correct.
That's a matter ultimately for assessment and judgment by the inspector, having regard to what he's heard from Mr Wadsworth and Mr Jackson. Would you agree?
Yes.
So beyond that, that's a matter upon which he can form a view either that there is an absence of conflict or there is conflict and what view he takes about that conflict from their evidence.
Yes.
Thank you. Criterion F seek to minimise the encroachment of development into visually exposed landscapes. I know there's a difference between our respective landscape experts as to whether or not this is visually exposed or not. That again, matter for the inspector.
Yes.
But in any event, it's not either a preclusory policy, nor does it say avoid such landscapes. It's a seek to minimise.
Correct.
Once again, within seek to minimise, that's a matter for the inspector as to whether or not the scheme has done so.
Correct.
Where the development is proposed on the edge of the village, that ultimately is probably a question of judgment for him as to whether or not the site which is outside is on the edge of the village or not.
Correct.
And similarly, what views he takes about views and whether or not there's an inappropriate incursion into surrounding countryside. That again, same bundle of elements. Policy is not directory to the outcome. Would you agree?
Yes.
Thank you very much. Now, I think there is general agreement that there are policies which are favourably inclined towards development of this sort. Would that be fair, having regard to the terms of the development plan?
Yes, the development plan does support employment development, yes.
And I'm not going to go back through the matters which are set out in the Statement of Common Ground, but essentially it is an element where there is looking for development to take place, development to provide for jobs, which we'll come to in a moment, and by reference to the Northampton development area, and that being something which is accorded with by this site. Would you agree?
Yes.
Yeah. So all of those would weigh in favour of that. Similarly, policy EC3. EC3 is not unqualified. This is where its focus is within the local plan part 2. That's KTP, and it's page 82 in terms of its hard copy numbering. And it's page 2447 of the PDF. policy to support new employment developments and schemes outside safeguarded sites, provided they meet the following criteria. The site has been comprehensively assessed. Don't think you can doubt it has been comprehensively assessed. Would you agree?
It has been assessed. I think the caveat there, but not for employment purposes, and this is the subject to this inquiry.
Well, okay. It's consistent with other relevant policies in this plan. That's a matter that relates to consistency with those other policies which we've explored. Yes?
There are conflicts with other policies within the plans.
Well, the conflicts that we've explored, where effectively there are judgments, but it would be open to the inspector in utilising the same criteria to conclude that there is no conflict. I know there's a difference between the two cases.
Yeah, yes, sorry, absolutely. The policy does allow development to come forward for windfall sites, so long as the proposals are in accordance with the policies within the JCS neighbourhood plan and obviously the local plan as well.
And we've partly touched on position of conflict with regard to the heritage issue.
Yes.
When I say conflict, including conflict between plans and looking at the most up-to-date plans. But it's a matter which I'll deal with in submissions, down as others will deal with you if I'm wrong about what I've put to you. So that question of consistency, matter for the inspector. And the proposed uses and the associated employment activities can be carried out without causing harm to adjoining land uses and occupiers, including residential amenity. I don't think there's any residential amenity issue here.
No.
No. So the only question about harm are those harms that have been identified referable to landscape and heritage, which we've already discussed.
Yes,
So there's no other harms that we need to be considering.
correct.
Thank you. Council supports windfall employment development proposals, provided the site has been comprehensively assessed as being suitable for employment purposes. The inspector is entitled not just to take account of what the appellant says, but also what the council's officers have said. Would you agree?
Oh, yes.
Recognising the point between us in terms of heritage and landscape, it has otherwise been comprehensively assessed, including that issue, and if the inspector were to conclude that with regard to landscape and heritage those are not reasons to withhold consent, then it would be suitable for employment purposes. Would you agree?
Yes.
Now, in terms of what the nature of the proposal is, that has been outlined, I think, sufficiently clearly. Number of jobs expected to be created. Again, I don't think that's a matter of contest between us.
No.
Potential impacts of the uses and occupiers on the surrounding area. I don't think that's a matter between us.
No.
Environmental, such as noise and pollution, and traffic considerations. Those are not matters between us.
No.
The potential impacts on the surrounding areas should also include matters such as impacts on natural environment and heritage and non-heritage assets. Just working backwards, I don't think there are any non-heritage assets we need to be concerned with here.
Correct.
Environment and heritage are the two issues which we've already discussed.
Yes.
And those are matters the inspector to deliberate upon. The site can demonstrate good accessibility by walking, cycling and public transport. Don't think that's a matter in contest. That is a site which is, I think by common agreement, has good accessibility by walking, cycling and public transport, doesn't it?
Yes.
Now, if you are going to have a windfall employment site, unless you are in a remarkable position of being able to recycle an existing, probably employment site, but a brownfield site, likely it is that you are going to be looking at sites which are going to be in locations which are countryside locations. Would you agree?
Primarily given the nature of Northampton, but I must caveat that the national guidance is very clear that we should be looking at brownfield development, and also there are policies within the plan that also do support, the reuse of the existing employment land as well for redevelopment.
I'm not suggesting those to be excluded, but where we are looking at new employment developments and schemes outside safeguarded sites, inevitably one is going to be looking beyond that stock.
Yes.
When I say stock of sites. So there is a likelihood that one would be within countryside areas, and it would be fair to observe that the Northampton related development area itself encompasses areas which could be described as countryside.
Yes.
So within the context of what the plan already expects, it's expecting that if there are such sites to come forward, the preferred locations for it to come forward would include the NRDA, including countryside areas covered by that designation.
As long as there aren't any other conflicts with the development plan, yes.
Yeah, well, inevitably those are matters that would need to be
Yes.
assessed and
Yes.
considered along the way. Thank you very much. So it'd be fair to observe that as a site for employment, this would be, subject to the caveats you've expressed, would be an appropriate location for employment development. Is that fair?
No, because as we've set out, that the key issues between us are around the heritage and the landscape impacts, and so those are the key issues that don't make it a suitable site for employment.
Forgive me. I recognise those are the matters which the inspector's going to have to adjudicate
Yes.
on those, and we're going to look at the weighting issue in a little while. But if the inspector concludes that those are not matters which constitute an overriding reason to refuse consent, then this would be otherwise an appropriate location for employment development.
Yes.
And among the features are the fact that it is within the NRDA, it's adjacent to Northampton, it's adjacent to Bracknells, and near to the lakeside.
Yes, along with everything we've just discussed.
And
Yes.
it's on the A428 and it has all of those features. Thank you very much. As far as BMV is concerned, it's not a reason for refusal.
Correct.
It's a fact to be taken into account. Something like 2/3 of the site would remain available for agriculture, whether pastoral use or otherwise. Yes?
Yes.
And I don't think you've indicated that there is a specific economic reason whereby the site should be retained in agriculture, nor is there any objection from whether or not it's natural England, DEFRA or otherwise, on the basis that it is currently in agricultural use. Would that be fair?
Yes.
So if the inspector were to conclude that the site was otherwise appropriate for development, the existence of the BMV on the site would not be a reason to withhold consent.
Correct.
Thank you very much. With regard to employment-related matters, maybe we'll be able to deal with this relatively quickly by reason of the matters agreed with by a statement of common ground and otherwise. Now, I don't think you sought to contest any of Mr. Robinson's evidence, is that correct?
That's correct.
So can the inspector record that so far as Mr. Robinson's evidence is concerned, you accept that and his analysis of the need for employment land? He's not being asked to determine the strategic need, I hasten to add, but you accept for the purposes of this inquiry his analysis and his evidence.
Yes, I just have to, obviously, Peter, I have to caveat the fact that I think the evidence that has been submitted and the critique of the HINA certainly will be very helpful to the council to make sure that when the next draft of the HINA comes out, the council will have been able to take into account the critique that has been made. I have not been able, it's not my area of expertise to critique the evidence that has been submitted. So on that basis, I accept that, the inspector is invited to look at the evidence. All I would say is that evidence has not been critiqued, it has not been assessed, or has any sort of, examination of that evidence been undertaken. But I accept that, I'm not contesting that evidence because I don't have the ability to do so.
Although it would be fair to observe, because it's not intended to be matters determining what the strategic need is in future, but the inspector is entitled to proceed on the basis that that is the best evidence before him, and it's evidence that the council does not suggest is incorrect.
Correct.
Yeah, thank you very much. Matters of weighting, if I may. In terms of weight scales, you've got a 3-part scale, as I've been able to deduce from your proof of evidence, which, and tell me if you agree or disagree with this, but as far as I can work out, as far as you have sought to attribute a value to weight on issues, you've either said it's significant, you've said it's moderate, or you've said it's limited.
That's correct.
Yeah. Mr. Kirby has come up with a 4-point scale, which is substantial, significant, moderate, and negligible. Where Mr. Kirby has used the word substantial, that is his top part of the scale, and you were taken, I think, in examination in chief to Mr. Kirby's table, which is on page 79 of his evidence, beyond his paragraph 8.5. To be fair, I think you ought to have before you Mr. Kirby's additional statement, insofar as that is relevant to tempering anything which is said there. Where Mr. Kirby has used the word substantial, which is either above your significant or will be the top end of your significant status, tell me whether or not you agree with that characterisation. Would you disagree with him using the word substantial to emphasise and to elevate the weight attributable to that feature?
That's a really interesting question around the interchangeable nature of substantial or significant.
Well, you both use significant.
Yeah. Mr.
Kirby's got it at effectively a lower level than you. It is your top level. So what I want to understand for the purposes of the inspector is whether or not you dissent, given his 4-part characterisation of weight, whether you would disagree with that, of indicating that there is something which in the significant hierarchy, your top set, that in actual fact it is capable of being regarded as being at the top end of your top set, if I put it that way.
Okay. So for clarity, so how I've interpreted the substantial way, I've seen that as Mr. Kirby's highest level. So I just want to be really clear that that is his absolutely top one, and then he's got significant, which is a lower.
Could you have? Can I just invite you to have a look at the last line of 8.5, where I think he's set out his scale?
Yes, thank you. Yes,
Not
the
at all.
substantial
No,
is the top.
is the top one. So
yes.
No, a very fair point for you to be clear on for that. But it's a 4-part scale versus a 3-part scale, and it's whether or not there is a material difference between you or you've just used a different scale and different terms. That's what I'm seeking to explore.
Yeah, and so I think that I've tried to keep mine. You know, there's no definition anywhere that tells you which ones that you should use. So I like to keep things very simple in connection with how I approach things. So for my significant is my highest level in connection with the weighting that Mr. Kirby has used. I have no issue with the approach that Mr. Kirby has adopted.
Right, because he's used substantial essentially being above significant. So you've used the same word, but it may well be that it has a different weighting connotation.
Yes.
It's whether or not you would say that is an overstatement in terms of his use of the word substantial, or whether you would accept that, having regard to those features, given that you've used the word significant, as has he, but his is to indicate a lower level of weight.
Yeah. As we have gone through, the only difference I think we have, where we've used the same one, for example, is the jobs I've given significant. I think in the
that's where your officers gave was significant.
Yes. So I just want to double check in relation to the jobs that hasn't changed in Mr. Kirby's proof. Because in his proof, he has given substantial weight to it. For the job creation, I have given significant. So obviously there is a difference there between us. And in relation to the table that we went through earlier in my evidence in chief, there are differences between us.
That's what I want to understand, whether there are real differences or differences in terminology. That's the reason why I'm asking the question. Let me put it in a numerical way, and I'm using that not because it is numerical, but just to try to give some way of explaining that. Let's supposing it's a 4-part scale, and let's supposing this isn't, I'm sure this is not the way Mr. Kirby assesses it, but let's supposing they were quartiles, so it'd be 25%, 50%, 75%, 100%.
Yeah.
So from that point of view, 25% for each. Yours would be 33% for each. It means that if you try to correlate the two, there is going to be potentially crossover, or not, as the case may be.
Yeah.
That's what I'm trying to understand between you, as to whether or not there is a real difference, or in actual fact you're both saying the same thing.
For mine, probably there is a difference between us.
Right, eh? So far as substantial, would you say that that was an inappropriate characterisation to weight in terms of the economic benefit on a 4-part scale? It's a high significant.
It is a high. It's significant. So if you put it in your your numbers, I would give that a number 3.
From bottom to top.
Yes.
Right. So effectively, but you're still saying effectively you're saying the same thing of significance.
Yes. Yes.
So it's effectively Mr. Kirby's category 3 rather than Mr. Kirby's category 4.
Yes.
Right. Okay. And similarly, with regard to matters relating to heritage, you've regarded, in respect of matters relating to heritage, that the weight attributable to harm is significant.
Yes.
Yeah. Now, obviously, that'll be a matter for the inspector to evaluate with regard to weight. But it would be fair to observe, wouldn't it, that so far as that issue on weight is concerned, you've got nowhere higher to go. So if you were dealing with someone causing a more profound effect in the setting, what Mr. Partington, or indeed even Mr. Bourne, both might regard as less than substantial at the highest end of the scale, that also would have the same characterisation from you as being significant weight, wouldn't it?
Yes.
And similarly, if it was substantial harm, that also would be the same characterisation.
Yes.
One of the features about characterisation and weight attribution is the issue of proportionality of looking at these matters, a matter I raised with Mr. Partington, that if you over-assess, or sorry, not over-assess, if you give an excessive weight to matters, that is indicative of it being the subject of an inappropriately high classification, because it indicates there's nowhere to go for matters that really are at the top end of, for instance, harm and weight. Would you agree?
Yes.
In that guise, from that point of view, the issue and the attribution of significant weight to something which is either, on Mr. Partington's view, is either low, moderate, or on Mr. Bourne's view, limited or moderate, and on Mr. Bourne's view is limited and at the lowest end of the scale. They're effectively being elevated by your significant weight by reason of that, from the lowest end of the scale up to effectively the highest end of the scale, because you can't go higher than your significant weight. That's right, isn't it?
It is, but I think that the reasoning for the giving of the significant weight is the fact that we are talking about the impact on 4 assets. So I do, in my judgment, is that is significant.
Well, but if one had 4 limited lowest end of the scale, for the sake of argument, why would that, because there are 4 of them involved, they may have levels of impact which are at highest, even on Mr. Partington's view, for 2 of the assets being moderate, and those obviously matters for the inspector to evaluate. But the highest, he says, is moderate, within the less than substantial. Yet you're giving that the level of harm, which is effectively, or level of weight to that harm, at the very highest end of your scale. That doesn't actually leave any headroom, does it?
It doesn't, however, my assessment is based on the fact that we do have 2 grade 2 star listed buildings.
The fact that they are grade 2 star listed buildings, one of them has lowest end of the scale, yes?
Yes.
By common consent. So it's only one of those that actually ends up with Mr. Partington saying moderate, Mr. Bourne saying lowest end of the scale. I say moderate, middle, I beg your pardon, and Mr. Bourne saying lowest end of the scale. So why is it that that elevates that to effectively the highest level of weight to be accorded against it?
Again, I think it's a judgment call, and my view is that that does afford significant weight.
Okay, I'll make submissions on it. Thank you very much. On some of the other benefits, if you have something where there is a plan policy that requires something to be provided arising from that, why does that potentially nullify the public benefit that's attributable to its delivery?
If an application requires something, in order for it to make it acceptable in planning terms, and it requires something to be provided, then that's why, in my view, there isn't an additional benefit of that proposal. It's the fact that it's required in order to make the development acceptable, and it's part of that policy.
Yeah, but the development plan itself, that is anticipating what might be the public benefits required to be delivered in order to make development acceptable in planning terms. It's not an impact charge, but it's to make it acceptable in planning terms. It's more broadly scoped than that. It doesn't need to be an additional benefit, does it?
No, and I don't think I've said that.
Right, but that's what you said a moment ago. So plan policy, that can actually provide what would be required to make something acceptable in planning terms. That doesn't mean to say that that wouldn't be a public benefit, though, would it?
As I've said in my when I was asked about the weight that can be attributed, for example, in the highways and the provision of a cycleway, I have afforded that it's not neutral, higher, because of the other people could benefit from that particular provision. So there are things that are neutral because they are required, and so we'd have to go through a whole raft of which ones have a wider benefit than which are particularly for site specific.
Well, it may well be that it's necessary to do things purely in order to, for instance, obtain access into the site, no more, no less. But in terms of public benefits elements to this, what I want to understand is why is it public benefits achieved via meeting plan aspirations, why those do not constitute public benefits in the planning balance? Because I don't think there's anything in the NPPF, I'm not aware of anything within any statute or other guidance that suggests that for the assessment of public benefit, those things which are required by means of satisfaction of plan policy are to be excluded as public benefits. Are you aware of anything which excludes any of those from consideration as public benefits?
I think we just need to be I'd like to be more specific, because the actual policy requirement for, in this particular case, an employment proposal, it does set out what things have to be taken into account.
Yeah, but that's not the point raised. In terms of public benefits, is there anything that you can point to that indicates that public benefits arising from the satisfaction of plan policy requirements are to be excluded from the assessment of public benefits within the planning balance?
No.
So, as a matter of principle, something which satisfies policy can be a public benefit,
Yes.
to which weight can be attributed.
Yes.
So, in terms of, for instance, the training exercise, the training provisions that are made within the this scheme, which is secured by the planning obligation, that's a public benefit, because but for this development, that wouldn't occur, would it?
Conversely, the application may be refused if the policy wasn't complied with.
No, well, and that would be a matter for deliberation, but the simple fact is, in terms of the benefit, not the sanction, but the benefit wouldn't occur but for the development.
Correct.
Yeah. So it's right for those purposes to say that that is a public benefit attributable to the development. Yes?
Because the policy requires that provision, then yes.
Yeah. But we've agreed that the existence of the policy doesn't prevent it from being a public benefit to which weight can be attributed.
Correct.
Yeah. So that doesn't matter for those purposes. So in which case, if you have the public benefit, you can take account of that public benefit for the purposes of evaluating the public benefits of the development, can't you?
Yes, you can.
Yeah.
And it's clearly set out, there's a difference of opinion between myself and Mr. Kirby as to the weight that can be attributed to those benefits.
Yeah.
And obviously that's something that the inspector, will form his own view in relation to the weight that he attaches.
Okay, coming back to that in a moment, thank you. Bear with me for one moment. Well, thank you very much. Thanks.
Thank you, Mr. Goatley. Is there any re-examination, Ms. Daly?
Yep, just one thing, thank you. Ms. Ford, you were asked about your weighting scale, and you agreed that you had used a threefold scale no benefit, limited benefit, moderate benefit, significant benefit, or significant weight, limited weight, moderate weight, sorry, or limited harm, moderate harm, significant harm. So a threefold scale. And Mr. Goatley characterised that as sort of 0 to 33%, 33 to 66, 66 to 100, broadly speaking. And you were asked some questions about the fact that you've attributed significant negative weight to the heritage harm that's been identified. And points were put to you about, well, if you had a case where there was substantial harm, then following your scale, you would put that into the same category, significant weight. And you said, yes, you would. Now, I'm just interested to understand, in terms of that scale, if you're in the category of, say, significant harm, am I correct in understanding that that would be from the sort of 66 to 100% category?
Yes.
And would you be, if you had a case where there was substantial harm caused to a heritage asset, and you said, yes, that should be attributed significant negative weight, would you be inviting the inspector to treat that harm in the same way as, say, the significant negative weight to the harm that arises in this case?
No, as I said, there's a scale, isn't there? So, if you have something of World Heritage Site, for example, I'd be putting it 100 within my sort of scale. So I think that's the sort of, there is a scale within a scale, as it were. So I do attribute significant weights, obviously, to the harm in this particular case. But that would probably be around sort of, the 70 mark. It's not a World Heritage Site, which I'd give 100, so hopefully that explains it. So there is a scale within a scale.
Thank you very much. I don't have any further questions.
Thank you. We will carry on now with the planning evidence from the appellant, and that's Mr. Kirby, I believe.
Please.
Good morning, Mr. Kirby. Welcome, Mr. Goatley.
Thank you very much, sir. Mr. Kirby, morning. Wow, yeah, still just morning. Good. Mr. Kirby, if I can introduce the inquiry, you're Jonathan Carl Kirby. You're Senior Director and Head of Office at Lichfields, and you're based at Corner Block, Cornwall Street in Birmingham. You're a member of the Royal Town Planning Institute, and you hold a Bachelor of Science degree with honours in Environmental Planning, Anglia Polytechnic, and a Diploma in Management from Reading University.
Correct.
You're instructed on behalf of the appellant to prepare and submit this appeal, and you set out the evidence that you provided this inquiry has been prepared and given in accordance with the guidance of your professional institution, and that's your true evidence. So thank you for that. In respect of your appeal, you have provided a proof of evidence, your principal proof of evidence, to the inquiry. If you have that before you, please.
Yes, sir.
And that is document L5. You've also provided this morning a addendum to your proof of evidence dealing with a small number of matters which have either arisen or you've identified for this. May be helpful at this stage for you to identify what those are, and then we will return to those in more detail shortly.
Yes, sir. Having listened to the evidence from the witnesses, in particular Mr. Bourne, yesterday, and having reviewed my proof of evidence, firstly, I had identified two examples, one within the summary and one at paragraph 7.141, when in the proof I'd used the word substantial, significant, not substantial. So I just sought to correct that for the purposes of subsequently discussing the weight to be given to matters through the heritage balance. But then I also thought, having listened to the evidence, that it made sense to recalibrate matters such that we had recorded what had been said during the course of the inquiry from the respective witnesses, Mr. Bourne and Mr. Partington, and to look at that against the environmental statement, so we could identify the level of harm to heritage assets that had been set out and then subsequently accepted, particularly in the case of Mr. Bourne's evidence. So that's set out in the table at 1.7 within my addendum note, and then I've subsequently sought to clarify the weight to which I would attribute harm against the different scenarios set out in Mr. Bourne and Mr. Partington's evidence, such that that can be considered within the heritage balance, which is embodied within my case. I think we've heard it at the table at 8.5. That then flows into the planning balance. I've not repeated all of those matters; they are implicit within the text. But consequently, that was the purpose for the note. No new evidence in there. It's really just to draw matters to a head and to make it easier for us all, having listened to the evidence over the last 3 days.
Thank you very much. Now, many of the matters have been canvassed hitherto during the course of the inquiry, so I'm not proposing to go through in detail seriatim with the matters that are set out in your proof of evidence. But doubtless if there are matters that fall to be contested, they will be. You set out in section 7, in particular, the principles of the case for the appellant. This is page 45 and following. That would represent, I think, a realistic starting point for the purposes of consideration here. Is the principle of development acceptable? Is the appeal site suitable for employment use? Is there a need for development? In the light of the matters which have gone before, including the evidence of Ms. Ford during the course of this morning, where do you say that we are at in respect of those particular principal contentions?
So I think it's in terms of is the principle of development acceptable? Is this an appropriate location for development to take place? I think it's now a matter of, within the statement of common ground, that the parties are in agreement with regard to the suitability of a site located adjacent to the principal urban area within the Northampton related development area as a location where it is appropriate for the development of economic-led development to take place, subject to the need to assess the scheme against other policies within the plan. And I think, as we just heard from Ms Ford, heritage and landscape matters are those that are pertinent to the inspector's deliberations.
Need for the development, is there a matter in contest, as you understand it, with regard to the need for additional employment development, having among other things heard the evidence from Mr Drummond, Mr Robinson and now Ms Ford, who accepted what Mr Robinson had to say?
Absolutely so. I think we start from the Council's committee report, which accepts that there is a shortfall of employment land. That's then was, in order to get to that position, evidence within the documentation supporting the planning application. It's been further corroborated by the evidence of Mr Robinson and the appellant's commercial evidence as well.
Thank you very much. Now, I went through in a little detail with regard to the policy basis for considerations proposal and the policies in particular that were identified in the decision notice, and indeed other policies which were identified in the statement of common ground as representing those most important for the determination of this proposal. Your views, please, as to whether or not those policies indicate that there is good reason to withhold consent in this case.
So would you like to take me through each of those policies on an individual basis so we know that we're talking?
Certainly. Take through the same policy suite, if I may. So far as the, and I'm going to deal with this essentially, I think in a similar order to that which I took through with Ms Ford. I'm going to start with the neighbourhood plan. And policy 1, neighbourhood plan. Is K12. You have that? Dealing first of all with policy 1 on the PDF, it's page 3 of 16. Went through each of those elements. None of those essentially had a justification for withholding consent. So policy 1, as far as she was concerned, didn't tell against the proposal. Your view, please?
I entirely agree, sir.
Policy 2 went through each of the criteria there. Anything that tells, as far as you're concerned, none of those criteria, as far as Ms Ford is concerned, apply?
Entirely agree, sir.
Policy 3 about design, because this is an outline scheme, although there was a discussion as to the issue of principle, then ultimately came to the view that it doesn't deal with the principle, it deals with the design of development, and that therefore none of that policy applies. Your view, please?
Design is a matter that will be dealt with as part of a subsequent reserve matters application in the event that the inspector were minded to grant permission, sir. So I would suggest that the policy is not relevant to the consideration of an outline permission at this stage.
Now, Neighbourhood Plan Policy 6, 3 criteria emerged for purposes of consideration: A, F, and H. Do you have those? Do you have that available to you? It's Policy 6.
I have.
Policies B, C, D, E, and G were agreed not relevant. A, F, and H were considered to be potentially relevant. As far as criterion A was concerned, Ms. Ford accepted that that was a matter effectively within the landscape considerations before the inspector, and not her own independent evidence from that point of view, but that was a matter that the inspector could either conclude positively or negatively in context of the proposal, consistent with policy. Your view, please?
I would agree. I think it's one of the substantive points between us based upon the evidence that was put forward by, on behalf of the appellant, Mr. Jackson, and the counsel, Mr. Wadworth.
Your criterion F, which is a seek to minimise the encroachment of development into visually exposed landscapes, as an issue between Mr. Wadworth and Mr. Jackson as to whether it is within that. Similarly, development proposed on the edge of the village, that's a matter of interpretation for the inspector as to whether the site, which is the other side of the A428, is on the edge of the village or not. Do you have a different view to that which Mrs. Ford as accepted?
So I would point out that the village has a settlement boundary defined within the local plan. There's obviously a conservation area boundary as well, and this site is not adjacent to that. So you can take the view that the environs surrounding the village include land outside of that area in general terms, but you could equally take the opposite view. I think that's one for the inspector to characterise.
If the inspector were to conclude it's not on the edge of the village, where does that provide in terms of the next part of it enhances views of settlement edge from the surrounding countryside?
Well, my view is the site is on the opposite side of the Bedford Road, and consequently it's not on the edge of the village for what it's worth. It is within close proximity to the village, but it's not on the edge of it. It's on the opposite side of the A428.
And the last component does not lead to inappropriate incursion into the surrounding countryside by reason of siting design, materials, or use of landscaping. Your view, please, as to whether it's an inappropriate incursion by any of those matters, or whether or not any of those matters are capable of being resolved at the reserved matter stage.
Yeah, I think they are entirely reserve matters items. We don't know exactly what quantum of development will actually come forward. We have a parameter within the definition of development. We do have a parameter plan which seeks to define land uses by definition, but it in no way ties development down to a specific format other than within the description of development. So I think that they are matters that would be properly dealt with as part of a subsequent reserve matters application within the parameters that would be set within the description of development and control emphasised within the parameter, within supporting parameter plans.
Thank you. Anything else on F that you would observe?
I think not, sir.
Thank you. Move to criterion H. I reminded Ms. Ford that this was a landscape policy with which she concurred. In context of that, integrity and fabric of historic buildings and their settings. A number of elements are bound up in that. We'll come on to particularly some clause in a moment. But so far as the integrity and fabric of historic buildings, by common consent, those are not engaged or involved with this proposal. Direction was related to settings. As Ford went to, seeking to conserve and enhance essentially listed buildings and their settings, particularly where new uses are proposed through the use of appropriate styles and sustainable locally distinctive materials. Where does a seeking to criterion take us in your view?
It enables the decision maker to conclude on that matter. It doesn't take you to a position whereby it is by definition directed within the policy to refuse or indeed permit a proposal. It is one for consideration.
Thank you very much. Looking next, I think that's everything in terms of the neighbourhood plan. Go next, please, to the joint accord strategy, which is K11. You have that?
Yes.
First of all, we're going to go to BN5. It's PDF page 31, page 121 of the document itself. You'll recall the exploration of this particular policy set during the course of this examination. So far as Ford was concerned, the absence of a balance point within this particular policy was neither here nor there because it had been through a process of local plan examination. Your view, please.
Yes, well, I think there are several facets to this which perhaps need to be explored. I think, firstly, the joint core strategy was appropriately adopted in 2014. It was then subject to a review in 2020, a 5-year review as required, and the council resolved that the plan was up to date. So that point I would agree with. The plan is up to date. The position moving forward is that the council have put in place Local Plan Part 2. Local Plan Part 2 and the JCS need to be read together. In fact, skipping ahead, if we actually go to ENV6, there's a specific point at the bottom of ENV6 which records that its purpose is to deliver the requirements of policy BN5. So we move to a position whereby we have a development plan that must be viewed as a whole, with BN5 and ENV6 seeking to achieve the same objective but saying slightly different things. Is it possible that we can have a plan seeking to achieve, or two policies within the wider development plan seeking to achieve the same things that say slightly different things and remain up to date? And I think yes, it is. Certainly that's what the PPG tells us, and I can give the references to that if we so wish. However, what we also need to bear in mind is that where those policies say slightly different things, we have to look at their compliance with the MPPF. And in this instance, and again, sorry, I can give MPPG references to direct us to that plan making section within the PPG if necessary. But the point being here is that there is a difference in the policies in that the NV6 includes that public interest test and BN5 doesn't, and they're seeking to achieve the same things. So there is a tension there. Para 35, which I think was mentioned earlier in the PCPA, talks about what to do in the event of a conflict between plans, where the plans are saying slightly different things, and it asks or directs that that resolution should be made in favour of the most recently adopted plan. So my view is that yes, the plans are up to date. Through the passage of time, it's inevitable that there will be change, but where we arrive at the point of change of wording in policies, then you have to defer to the most recently adopted policy, and you have to look to what the MPPF is suggesting in accordance with that policy. And in this instance, that public interest test is absolutely critical, because what it does is it creates, as the MPPF intends, that balance to be struck between the public benefits that arise from a proposal and the consideration of any impact of development where that has been identified.
Thank you very much. If we can just stay with, if we may, ENV6, to which you've made reference. This is in the plan part 2. Which is K. K14. As far as ENV6 is concerned, are there any components in there, having regard to the features there, which leave out of account any aspect that needs to be included for the purposes of the heritage component of any planning balance?
No, sir, absolutely not. I think if we were to run through the criteria, we can see that the development proposals, as a result of the technical analysis that's been undertaken, have demonstrated a clear understanding of the significance of those assets. Those assets have been incorporated into the development proposal, taking into account the potential impacts. Those impacts have been assessed, and then when we get to criteria 3, there's a clear and convincing justification, which I would suggest is enhanced within the, or set out within the documents supporting the application, and now within my proof of evidence and those of my supporting witnesses.
Thank you very much. South Northamptonshire's plan policies as material considerations themselves. Assist me, please, as to whether or not your views that they are appropriate to be considered or not considered in context of a deliberation on this proposal.
So my view is very clearly that South Northamptonshire local plan is not relevant. I think I've included on page 18 of my proof an extract from the South Northamptonshire local plan. I haven't, perhaps unhelpfully, identified exactly where the site is on that plan, but we can, I think, by association with the information that's been discussed over the last 3 days, relatively identify that site. This site is outside of the area to which the policies within the South Northampton local plan apply. So my view is that the South Northampton local plan cannot be applied to development within or outside of the former South Northampton local plan area. However, notwithstanding that, it is quite clear that the relationship between surrounding assets is a material consideration, as you would expect, and has been considered. It's just a difference of opinion between the parties, I believe, as to whether it's relevant to consider those through the jurisdiction of the South Northamptonshire local plan or the NPPF.
Thank you very much. Now, we've touched lightly on the existence of the Northampton-related development area and the principal urban area of Northampton, and indeed the requirement for job provision, which fairly Ms Ford, in her evidence, accepted all directed supportively in favour of the proposal. Do you take a different view to her?
No, I believe that the relevant policies support development coming forward within the NRDA, obviously subject to assessment of those relevant impacts against policy within the plan.
Thank you very much. So, first of all, within the terms of the development plan, recognise that there are matters for weighting, which we'll come back to in a moment. But as a matter of principle, how is this proposal capable of being assessed in context of the development plan?
Well, I think if we start probably from the statement of common ground, that sets out quite clearly development will be concentrated primarily in and adjoining the principal area of Northampton. I think it is the consequence of the word primarily which suggests not only. And if we look at the statement of common ground, the parties are in agreement that the site adjoins the built-up area of Northampton and that it's an appropriate location for development. Similarly, with regard to policy S4, it's agreed that the proposal would be in accordance with S1 as it adjoins the principal urban area of Northampton, and it's agreed that policy S4 is supportive of the principle of development. It's caveated, but only if it meets the vision needs and policies of the plan, which is essentially where discussion has taken place over the past 3 days with regard to the technical and environmental matters that need to be assessed.
Thank you. Now, so far as the NRDA is concerned, Ms Ford fairly accepted that included areas which could presently properly be described as countryside. Is that a description you would concur with?
I think absolutely the NRDA actually, as far as I'm aware, includes the whole of Northampton's administrative area, not just the PUA. Obviously, Northampton is an authority with a tightly drawn boundary, so I would assume that when the NRDA was drawn up, there were limited options for accommodating growth, and consequently the NRDA was put in place in order to enable the wider consideration of opportunities for growth that may well come forward, either within the town, on the edge of the town within defined SUEs, or within future windfall opportunities that may arise. And that's essentially what the policy framework was put in place to achieve.
In those circumstances, how would you assess landscape-related objections as a matter of general principle for the consideration of proposals that would arise in the NRDA but out with the urban area as currently conceived?
Well, policy requires that landscape is taken into account and the effect of development. So I think you can't necessarily in a broad brush fashion suggest that the NRA is a an area that could, without exception, enable the release of land to come forward. It has to be on a site-by-site assessed basis, and that's exactly what EC3 is seeking to achieve, is to enable the implementation of the WNJCS policies to achieve the quantum of development that was identified, and to deliver jobs and economic growth. That's what the purpose of the NRDA is.
Turning to the issue of economic growth, we've obviously received and heard the evidence of Mr. Drummond and Mr. Robinson, none of which evidence is contested by Ms. Ford or by the Council by rebuttal or otherwise. What do you say about the assessment of that evidence and the significance of any of that evidence for the purposes of the evaluation of any case, particularly if one is dealing with a public benefit case in respect of heritage impact?
Well, I think the starting point here is at a national policy level that economic growth is to be given a significant importance in terms of facilitating growth within growth nationally. I think at a local level, within the context of Northampton, there is an acceptance from planning committee report from officers through to the statement of common ground that there is a need for the release of additional land to meet economic growth. That was recognised both in the evidence from Mr. Robinson. We started from a figure that was quoted within the committee report. Mr. Robinson's analysis is that that level of growth was much higher. That was then taken into account, reviewed in terms of market demand, and we got to a position whereby the commercial evidence here is such that there would appear to be a shortfall of available accommodation, which by definition has the potential to suppress the ability of firms to come forward and jobs to be created. I think that's compounded in this instance by the fact that the JCS at paragraph 3.17 specifically intended to review the Northants spatial plan, as it is now known, by 2020. That process has begun, but the plan remains, the WNSP remains at an early stage. It is coming forward, but of course the issue that creates is that the existing JCS, and by definition the Northampton Local Plan 2, has a plan period that runs to 2029. That gives I was going to say 6, it's not even 6, it's 5 years and a month of plan period. And whilst that's all Northampton Local Plan 2 could actually achieve, obviously, because it is part of the JCS, it does mean that in terms of the future allocation of land, it's obviously defining land over a shorter period than would perhaps be the case were the West Northants strategic plan at a much more advanced stage, perhaps having been reviewed in accordance with the intended timetable. And that creates, obviously, a difficulty in terms of the availability of land over the foreseeable future for businesses to expand, grow and deliver jobs. I think we can also see, obviously, that the level of jobs was largely on track, has gone backwards and forwards over the past few years as we've seen changes within the economy. It hasn't yet achieved that target. It may well ramp forward and do so, but it may also stumble as the economy moves into its next phase. We're not crystal ball gazers, we can't predict where that is, but what we can see is that based upon the evidence that there is a shortfall of employment accommodation and a desire of business to come to Northampton to continue the journey which the WNJCS objective and vision sought to achieve, which is to grow the local economy, to make Northampton the centre of that local network of surrounding towns in terms of economic growth.
Having regard to the evidence of Mr. Drummond as well as that of Mr. Robinson, is this just a sort of a statistical extent of shortfall as far as you understand it?
No, I think there is, given particularly Mr. Drummond's evidence, there is a particular shortfall that is identified within the signals coming from the market, which isn't being satisfied by the land that is available at the moment.
And has anything been identified that is likely to resolve that in the near future so as to obviate the need for a site such as this?
Well, I think, looking into your crystal ball, if the WNSP were to rapidly speed up, then the council would be in a position to move forward to identify further releases of land. However, that document remains at a very early stage. Its evidence base, we know there's a revised HENA coming, but we don't know when. Its evidence base has been identified as having some issues by Mr. Robinson. Those matters need to be resolved. We don't know when the local authority is actually, we can see there's an LDS in place, but we don't know when that's going to come forward, what difficulties the plan will encounter at examination. All of these are matters for the future. What we do have, however, is a policy within the Northampton local plan which envisaged the need potentially to achieve flexibility within the employment land supply in accordance with the requirements of the MPPF to secure the potential release of windfall sites, albeit those windfall sites, as we've said, need to be assessed against the environmental and technical consequences of development.
Thank you very much. Now, you've provided your weighting exercise in your main proof of evidence. You've also provided your addendum note in order to indicate 2 corrections to your main proof, and also what you consider to be the appropriate weighting exercise to be undertaken. This is I think on page 3. Now, one aspect, if I can highlight in particular, and that relates to the matter of the heritage harm. You've set out on the table on the second page of your note the views of the competing witnesses and in the light of Mr. Bourne's evidence that he gave yesterday. You, on the previous page, page 1, note about the great weight that needs to be given to impacts on heritage assets. You carry out your own weighting scale in the light of Mr. Bourne's evidence and reflecting upon that of Mr. Partington. In a nutshell, tell us about where you say you are at in terms of your evidence to the inspector as to the weight that you say ought to be attributed to the heritage harm within the planning balance.
Yes, sir. Well, I think if we start from, and I hope I have reflected accurately, I have to say, the outcomes of those considerations by witnesses over the past few days. I'm sure it will be pointed out if I have got something in error in there. But hopefully I have that identified correctly. What I would observe is that based upon the revised position that Mr. Bourne accepted following the examination of his evidence, is that in all instances the assessment of impact upon heritage assets is less than substantial harm and at the lower end of that scale. So we start from a very low baseline position in terms of identifying that impact. There is certainly identified harm there. We're not into a position where there is no harm. It is less than substantial. We do have 2 conservation areas and 2 Grade 2 star listed buildings, so we need to factor that into that weight. But I'm struggling to see how you can conflate harm at that lower level to a moderate or even higher significant level of harm based upon Mr. Bourne's evidence. So my view is that there is harm, it's at a lower level. You have to give it great weight in terms of the assessment under the MPPF, but it is at a lower level. So my view is that, and it is a judgment as ever, it is that that would be at a negligible level. I think if we take Mr. Partington's position, he has also concluded in all instances that the harm would be less than substantial. In 2 of those instances, one in relation to a conservation area, one in relation to a Grade 2 star listed building, he suggested that less than substantial harm would be at the middle of a range, but it is still less than substantial. So my view would be, taking Mr. Partington's position, perhaps we suggest that that would be a moderate level of harm. I really can't see how you can take those assessments and get to a significant level of harm in any instance there. I think had it been less than a different outcome than less than substantial, we'd be in a different ballpark. But of course, we are here to make judgments. That would be mine. I'm sure the inspector will reach his own judgment based upon the facts that have been put forward. That would be my view, sir.
Thank you. Well, matter which might just push it a little further, and that is, Mr. Ford said, yes, but here we've got 4 heritage assets. We've got 2 Grade 2 star listed buildings, 2 conservation areas, and that by reason of that, that's sufficient to justify a significant level of harm, taking them in the round in the aggregate. Your views in respect of that?
We need to deal with what the actual, we heard the evidence from the witnesses, we need to deal with what the actual extent of harm is. We're not removing buildings, we're not damaging buildings or heritage assets, we're affecting glimpses in many instances of those buildings within the context of what we heard is, and what we've observed is a much wider landscape. You're not taking away the views or the setting of those buildings, you're having an influence over that in terms of a small part of that wider experience of buildings. I'm not a landscape witness, I heard from those landscape witnesses that discuss those elements. That's, I think, how I would categorise dealing with those matters. And that's why I would suggest I really don't think that could stretch in terms of my professional judgment to a significant level of harm.
As far as landscape impacts are concerned, landscape harm, what, if anything, do you say about that?
In terms of landscape harm, we heard from the different witnesses. What we do know is that the site is not doesn't sit within a protected landscape of any designation. There was a debate around whether or not the landscape is enclosed or exposed. I'll leave the inspector to determine in respect of that. But I'm struggling to see how, if we are going to have, if development is going to take place on a windfall site, it is inevitable that there is going to be change. Any development results in change. What, in terms of dealing with the landscape judgment, I think we should be dealing with here perceived impact will probably be higher. You're dealing with land that has no designation. It's at the other end of that spectrum, and surely if we're going to release an area of windfall development, it's better to do it in an area that has a lower level of perceived landscape value than one in a higher area of perceived landscape value. But the reality is that development is going to take place. By definition, it will result in change. Here, we have a site that, at least from Mr. Jackson's perspective, has been assessed in terms of having a low level of landscape value. And consequently, to my mind, I think that's probably where I would prefer to see development at professional level taking place, than somewhere that has more of a recognised, defined, valued position in policy terms.
Thank you very much. Now, notwithstanding what you've said about the development plan, or otherwise, what if the inspector were to conclude that there is some remaining conflict with the development plan, how would you say that you ought to then go about making a decision?
If there is to be an identified conflict with the development plan, then I think the development would fall to be considered against the material considerations that would arise, and notably the public benefits that would be delivered within the planning balance that would apply to development. And in this instance, given the significance or the importance of achieving economic growth that's embodied within national guidance, I would suggest that the delivery of the associated jobs and gross development value, and in fact here, given the evidence we've heard about the shortfall of supply, the floor space that would flow from the release of this site for development, I would give those a important material consideration in terms of the assessment of those assessments of the scheme against that perceived harm.
As far as those considerations are concerned, would they be sufficient in your view in order to justify a decision which was thereby, in that instance, under that scenario, contrary to the development plan?
Yes, absolutely. And I think if we were to work through those in terms of those public benefits set out at table 8.5, then we can explore why I would suggest those benefits are important. I mean, we talked about the weighting to be given, whether it's negligible, moderate, significant, substantial, or the three layers of criteria which Mr. Ford has used. But actually, if we were to take, for example, the level of delivery of jobs, that aligns entirely with policy 81 of the NPPF in terms of the desirability of generating economic growth. It must be a given. I would suggest, depending on whose weighting you use, the highest level of that weighting. I've used substantial, Mr. Ford has used significant, both at the higher level of the assessment that we both given. As far as generating gross value added, I've said substantial because it aligns with the importance of achieving economic growth. If you don't have the construction and the jobs, then you won't achieve the gross value added. They're inextricably linked. I would suggest, therefore, need to achieve the same weighting. We can talk about that in terms of the environmental statement and the value that was attributed as part of that assessment, but the fact of the matter remains that a development of this nature will generate a significant level of activity around the construction phase of development, some of which will be retained locally, some of which will inevitably flow off to other providers. It will also generate, once development is operational, significant levels of retained expenditure within the local economy. So I think it is, I'm struggling to see how you can give anything other than that higher level of valuation of those benefits. I think as far as training is concerned, equally, I'm struggling to see how you could give anything other than a significant level of weight here. I think if we were to refer to paragraph, policy E6, and look at paragraph 8.31 of the JCS, what it actually says is having the right skills is crucial to sustaining economic growth for the economy to be able to adapt to change. Well, isn't that what the JCS is seeking to achieve here in terms of delivering economic growth in Northampton? Yes, there's a policy requirement within E6, but no development, no training opportunities. Again, one's linked to the other. I think because the development is proposed, it doesn't mean that you can't take on board the benefits that accrue with it. That would be perverse. So I would give significant weight in accordance with 81 of NBBF to the delivery of training opportunities for the future employees of the development. I mean, that's an absolutely critical thing that new economic development should be doing. You should be reaching out and offering those training and apprenticeship opportunities to local people. I think we heard from Mr. Robinson with regard to the juxtaposition of areas of identified deprivation where those opportunities may arise. The Section 106 isn't specific about where those people's potential apprenticeships should be drawn from, but is providing an opportunity that could be accommodated. I think the implementation of training is down to the training provider. I think the opportunity can be provided there. The council is in control and working with that training provider to ensure that those opportunities align. And I think, as we said, we talked about the delivery of the floor space in itself. Yes, it's embodied within the proposal, but given the evidence of Mr. Drummond and Mr. Robinson in terms of need, in my mind, that has to be given a substantial weighting in any assessment of material consideration. Policy EC3 is seeking to facilitate flexibility to ensure that circumstances such as this, whereas the plan is perhaps unable to deliver based upon identified areas of allocation, because of the fact that the plan's been that successful in terms of identifying land that needs to come forward, or perhaps where the economy has grown faster than was perhaps anticipated. So the delivery of that floor space meets a need which will deliver the vision and objectives of the JCS and NLP2 to facilitate economic growth in Northampton. It has to be given a substantial weight. The delivery of the off-site highway improvements, well, actually I do take issue with the level of weight that was suggested by Ms Ford in the context of that. We had a local resident here the other day, Mr Jaggard. Mr Jaggard identified that there are concerns from the local community. In fact, I understand that there have been some accidents, unfortunately, that were identified. But it was also suggested that people tend to use Bedford Road as cyclists rather than taking the route through Bracknell. Well, this scheme will include a new 3-metre shared footway that will be specifically on the southern side of Bedford Road, where local residents will be able to take benefit of that. So at the very least, I think that should be afforded moderate weight. It doesn't just deliver a development-related requirement, it actually will be of significant benefits to the local community. So in my view, moderate weight. So I think actually in terms of enhanced biodiversity, and again we are on the same page with regard to that at moderate weight, so let's not dwell on that one.
Thank you. Can I have a couple of points, please? One is the principle of reduction in weight by reason of the fact that it is a plan policy purposes of delivering a public benefit. Your view, is that appropriate, inappropriate?
I entirely disagree with that point. You know, by analogy, if you have a housing allocation, we could talk about the housing allocation of the green. If that proposal delivers the policy requirement in respect of affordable housing, is that not a significant benefit to the local community that would otherwise not be delivered? I think the delivery of plan-related development has to be a benefit that must be taken into account.
Thank you. Second is, it's not a matter I think to which great time needs to be devoted, but the idea that for the purposes of a weighting exercise on this proposal, the attribution of weight to the gross value added of the development is by reference to the existing economy of Northamptonshire. Your views in terms of that particular coefficient?
Well, the development isn't currently there. So if you bring forward new development, there is an associated impact of that. And that impact here is about generating that gross value added that wouldn't otherwise occur. So it has to be a benefit that's taken into account.
But it said that benefit, or the evaluation of that benefit, is it's only going to be a very small proportion of what will happen in the economy. Is that an appropriate metric in your view?
Well, in terms of the wider economy, yes, it has to be. It's recorded within the environmental statement. We're not going to move away from that. We have to accept that. It has to be accepted that it's not there now. If the development takes place, then there is a district-wide and localised benefit that would not otherwise accrue as a result of the development taking place.
Thank you very much. Kirby, is there anything else you'd like to add at this stage?
No, sir.
Thank you very much.
Thank you. It's 5 to 1. I think this is an appropriate time to break for lunch. And we will, I think, reconvene. Sorry.
I was just going to suggest we could have a slightly quicker lunch and come back in 45 minutes.
I'm happy with that if everybody else is. Yeah. In that case, let's come back at 20 to 2. Yeah, 1:40. Yeah, thanks. Good afternoon. We're now at 13:40. So we'll start this afternoon's session. Ms. Daly, cross-examination. I think we're having to sort the sun out again.
Do I have anyone to cross-examine at the moment?
Coming out of the sun.
I'm not sure. There could be times. Do you want to move the desk forward so it's not in your... Yeah, because otherwise that's not...
Yeah, can we follow so far?
It comes this way in the afternoon. So yeah.
No, but the council tried earlier. I'm sure it's not done on purpose.
No. Perhaps at all.
Good afternoon, Mr. Kirby. Just a few preliminary matters. You tell us in your proof you started acting in respect of the site in 2019. Now, just a similar point to the one I've asked other witnesses. Does that mean that, just in terms of your input, did you prepare the planning application? And so were you the author of the planning statement that went in?
I oversaw the preparation of the planning statement and input to, I would say, large parts of that. The author was a colleague of mine who is no longer with us, actually.
Okay.
But I was responsible for the preparation of the planning application.
Fine. And in terms of the appeal, were you responsible for the drafting of the statement of case? Yeah. Okay. And were you involved in the promotion of the site through the NLP2 local plan process?
Yes.
Okay. Did you appear at the EIP?
Yes.
Ah, okay. Then you'll have met Mr. Sturgis before, presumably. Yes. Okay. First topic is principle of development. We've already looked, or you've already looked at policy S4. You can turn it up if you like. That's in K11, the Joint Core Strategy. And it says, doesn't it, that additional development to meet Northampton's needs will be supported only if it meets the vision, objectives and policies of this plan, correct?
Correct.
And it's obviously a matter between us as to whether the proposal meets the heritage, landscape and best and most versatile agricultural land policy of the Joint Core Strategy. What I'd like to do is look at the vision and objectives of that plan. So if we can look at Joint Core Strategy, starts on section, it's in section 4, it starts on page 9.
Of the JCS?
Of the JCS, yeah. That section's entitled Spatial Portrait, Vision and Objectives, and it's not until page 19 that we actually get the vision. Just tell me when you're there.
Can you tell me which page we're on? An internally navigable PDF.
Internal 19. Are you there, Mr. Kirby?
Yes, I am.
Yeah. And that says, in our vision of the future, the area will form an outstanding UK location of choice for diverse employment opportunities, academic, vocational, educational attainment. It also says a few lines down, the rural areas will include vital and tranquil villages within its rolling landscapes. And then it says lots of other things that are more specific to Northampton, Daventry, Towcester, etc. We then go down into the spatial objectives, so at page 20, spatial objectives dash how we get there. To ensure our vision is achieved, the following 16 spatial objectives have been identified and provide specific direction to the policies. And then there's a list of those 16 policies. And if we can have a look, please, at firstly, objective 8, economic advantage. I think this is one that you mentioned in your proof of evidence, correct?
Yep.
To strengthen and diversify West Northamptonshire's economy by taking advantage of our internationally well-placed location, strategic transport network and proximity to London and Birmingham. But then we must also look at objective 15, high quality design, to achieve high quality design in both rural and urban areas that takes account of local character and heritage and provides a safe and healthy and attractive place to residents, visitors and businesses. Do you see that?
Yep.
And then 16, heritage, to conserve and where possible enhance through carefully managed change the heritage assets and their settings of West Northants, and to recognise their role in providing a sense of place and local distinctiveness. So in terms of the objectives of the plan, there's obviously an objective to take a positive approach to employment, development, economic growth. The other two policies I've referred to, objectives that I've referred to are about ensuring that high quality design is achieved and that heritage assets are, where possible, conserved and where possible enhanced. Now, there's no prioritisation, is there, in the JCS of one objective over another?
Agreed.
And as we've seen, in order to comply with policy S4, the development would need to be consistent with both the vision and these objectives taken in their totality, rather than just, say, the economic growth objective. Do you agree that?
When we move from vision to policy, obviously we also need to take into account not just that policy, but other policies within the plan.
Just listen. Do you want me to?
The development plan
that's
as a whole.
Not my question.
Okay.
Would you like me to ask the question again?
I agree.
So you agree with? Okay, thank you. And I think what you're trying to say is that you should take into account other policies in the plan. I'm not disputing that. Similar exercise for the Part 2 plan, so if you can turn that up, please. And I think the vision is in chapter 3, page 35. Now, the windfall policy in the Northampton Local Plan Part 2 EC3, it doesn't specifically refer to the vision and objectives of the Northampton Local Plan, so I'm not suggesting that meeting these is a policy requirement. I do want to have a look at them though. So with that caveat in mind, Chapter 3, page 35 sets out the vision. By 2029, Northampton will be the heart of West Northants, playing a key role in the Oxford-Cambridge corridor. It also talks about, based upon a thriving mixed economy and associated services, it will be a place where history, innovation and regeneration are mutually supportive. The second paragraph, Northampton will be a great UK location for a range of employment opportunities. It will build on its economic strengths, including its location at the heart of the county in the Oxford-Cambridge corridor and as a prime area nationally for high-performance engineering and as a logistics and distribution centre. Final paragraph, it will blend high-quality design choices with outstanding public open spaces, distinctive historic character, etc., etc. So it's quite a similar picture to the JCS vision, isn't it?
Yeah.
And let's then look at the objectives in relation to the Part 2 plan. Page 36, para 3.2.1, the strategic objectives are based on those in the JCS, but they've been updated to take into account consultation responses to date and more recent evidence. The relevant objectives that I'd like to look at are Objective 1, high quality design and place shaping, to achieve high quality design that takes account of and improves local character and heritage and provides a safe, healthy and attractive place for residents, visitors and businesses. Do you see that?
Yes.
And Objective 4, economic advantage, to strengthen and diversify Northampton's economy by taking advantage of the internationally well-placed location, etc. And then objective 6, the heritage objective, to conserve and where possible enhance through carefully managed change the heritage assets and their settings, and to recognise and elevate their role in providing a sense of place and local distinctiveness. And again, we don't have a vision and set of objectives that prioritises one objective over another. It's employment, economic growth, as well as looking after design and landscape and heritage, correct?
Correct.
And then at page 39, para 4.1.1, we have a clear articulation of that. So it says, the aim of this local plan is to ensure that the growth requirements for Northampton are met in a sustainable manner. This means that Northampton's needs, including those for housing, jobs, retail and leisure, should be met in such a way as not to adversely impact on its built and natural environmental assets. Do you see that?
I do, yeah. I'm also looking forward to SD1, which I'm sure you'll come on to.
Well, I wasn't. Is there something you want to say about SD1? I wasn't going to ask particularly about it.
Well, I was just going to say that the overview of Chapter 4 is obviously the precursor to SD1, which sets out what the local authority is aiming to do in terms of how it approaches development proposals by maintaining a positive and flexible approach, obviously caveated with regard to the matters you've just talked about in terms of the social and economic conditions. So I think we're on the same page, but I just wanted to draw attention to that positive and flexible approach.
No, you must do that. Good, okay, and I don't think we need to go there, but we know that policy EC3, which is the employment windfall policy in this local plan, it states that, amongst other things, that the acceptability of an employment development depends on the proposal's consistency with other relevant policies in the Northampton Local Plan Part 2 and other development plan documents. So in that sense, it's wider than the S4 policy because it's drawing the consideration of policies out to other development plan documents. Okay. And again, in relation to EC3, the matter between us is consistency with heritage and landscape policies, correct?
It is, although I would draw you back to SD1, Part C, given I've got it open, and specific words within that policy, which I think have a relevance to how the council must approach development in accordance with that development plan with regard to taking it on board.
Sorry, I think I misheard. Did you say SD1C?
No, SD1, sorry.
SD1.
SD1 Part C.
Part C.
Yes.
So it says, where there are no policies relevant to a planning application or relevant policies are out of date at the time of making the decision, then the council will grant permission unless material considerations indicate otherwise. I don't understand your case to be that there are no policies relevant or that the relevant policies are out of date.
You are correct, ma'am.
Yeah.
I was focusing on the bottom part of that policy.
Sorry? Sorry, you just
you,
have to speak up.
Sorry, I said you are correct, ma'am.
Okay.
I was focusing on the bottom half. Of
Fine. So we're not in a
pirate.
SD1C world, are we?
No, we're not.
Good, okay. Now, just whilst we're in the Northampton Local Plan Part 2, you were taken to a number of policies by Mr. Goatley that he suggested were relevant to the determination of the appeal and were the most important policies. Now, one of the most important policies that's cited in the Statement of Common Ground is on the next page. It's policy Q1, placemaking and design. And that policy, I think previously it was emerging policy 2 of the Local Plan Part 2. It's cited in the reason for refusal. So on page 41.
I have it.
You're not resiling from the position in the Statement of Common Ground, are you, that that's a relevant policy for the inspector to consider? Good, okay. And we can see that it states policy Q1A, development should be designed to promote and contribute to good placemaking through high quality, beautiful and sustainable design, which encourages the creation of a strong, locally distinctive sense of place by, amongst other matters, Roman 4, responding to and enhancing locally distinct townscape, landscape and historic environment characteristics. And then over the page, Little 6, sustaining, protecting and enhancing heritage and natural environment assets, including non-designated assets and setting, and those included on local lists, etc., etc. And then little Roman 7, having regard to safeguarding or enhancing the setting of locally distinct places, including those found in conservation area appraisals, in terms of scale, design, landform and integration within the existing local context, to protect their identified important and unique characteristics based on sound, consistent analysis. Do you agree that those 3 sub-criteria are relevant to the consideration of this proposal?
Yes, ma'am.
And just on little Roman 6, that policy criterion also doesn't include an express reference to the balancing the any heritage harm against public benefits. I didn't detect that you were suggesting that policy Q1 was inconsistent with the MPPF, but could you just help me with that?
Well, there is a certain, if we are talking about this policy in the context of being a heritage-related policy, then I think there is a certain tension between those competing policy requirements. If it is a landscape policy or a design-related policy, then no. But where we have the development plan policies rubbing against each other with competing requirements, then I think it becomes important to take that into account, although notwithstanding that, clearly Q1 and the other policies in the plan were examined at the same time and are up-to-date policies.
Okay, so are you or are you not alleging that policy Q1, in failing to include a specific reference to the public benefits balance in the MPPF, is consistent with the MPPF?
Well, in respect of where it relates to heritage matters rather than other matters.
Yeah, I'm asking you about heritage matters, little Roman 6.
Okay. Then there is, well, it's simply not there, is it?
Is it consistent or inconsistent? I appreciate it's not there. The question, you've alleged inconsistency in respect of policy BN5 and a number of neighbourhood development plan policies. You haven't alleged any inconsistency, as far as I've understood it thus far, in relation to this policy. I'm asking if the position in principle that you have taken in relation to BN5 and the neighbourhood plan policies also applies to this policy.
Well, Q1 is a placemaking design policy to start with, that's its title. But if we are taking Q1-6 as being a heritage-specific policy, then there is a tension there. There is a need for that policy, I would suggest, to take into account public benefits. Okay, attention and need to take it into account. Is it consistent? Should it have been found sound, this policy, or not, in the local plan process? It depends if you're taking it as a placemaking design policy, which is the title of the policy. Yeah, I know what the title of the policy is, but we can see that it includes reference to sustaining, protecting and enhancing heritage assets. So in that context, forget what the title of the policy is in that specific context. I'm not suggesting that you might be saying that the entire policy is inconsistent with the MPPF, but that particular sub-paragraph, is it in your BN5 category or is it in a different category? In my opinion, it would have been perhaps more helpful had it included some reference to public benefits. It doesn't. That's what we're dealing with in terms of policies. We have to consider those based upon our viewpoint. Okay, so more helpful if it had included it, but you're not, I think, alleging that there's an inconsistency. Is that, am I right to record that? Yes, ma'am. Yeah, okay. I just put the local plan part 2 to one side for a moment, and just whilst we're on the most important policies for the determination of the application, there's another policy that's agreed between the parties as one of the most important policies that Mr. Goatley didn't take you to, and that is policy S10 of the joint core strategy. It's on page 56. Sorry, which policy one?
Policy S10, page 56
Of the JCS?
of the JCS.
Sorry, I was on the wrong plan.
And it says development will, little I, protect, conserve and enhance the natural and built environment and heritage assets and their settings. And you agree, don't you, that that is a relevant policy for the inspector to consider?
Just reading it up. Yes.
Good, and again, there's no specific inclusion of a public benefits balance. You haven't hitherto alleged that S10 is inconsistent with the MPPF. Does that remain the case?
No, I don't think it does.
You think it's inconsistent?
I think it is inconsistent
Okay.
in that particular point with regard to heritage matters.
Okay, so we've got BN5 and S10, but not Q1. Okay, that's clear. Now, just sticking with this point about consistency of development plan policies with either with each other, so with ENV6 or with the MPPF, can I ask you to turn up the planning statement, please? That's at A2. And I'd like to look at section 9, page 34.
Yes.
We'll just wait a moment for the inspector to get there as well.
Could you give me the page reference again,
Yeah,
please?
it's page 34, section 9. This is the part of the planning statement that refers to heritage and archaeology, and it talks about at 5.152 about the desk-based Orion assessment. Excuse me, then at 5.155, there's some comments made about the impact of the proposal on Great Houghton Conservation Area in the Grade 2-star listed church. There doesn't appear to be any identification of harm within that paragraph. 5.156, when considering Little Houghton and the heritage assets identified, it is recognised that there will be some reduction of rural views towards the conservation area from Bedford Road. However, on balance, this is considered to be less than substantial harm. So I think we can see there that there was, in the planning statement, some harm accepted in relation to Little Houghton, and says the heritage assets identified, let's take it as St Mary's Church. Do you see that?
Yes.
And we can see at 5.157, in summary, the assessment has shown that the construction and operational stages will result in no more than a minor adverse impact on significance. That's environmental statement language, but that is an identification of harm. 5.158, accordingly, the proposed development would be fully in compliance with policy S10 and BN5 of the Joint Core Strategy and the guidance within the Joint Core Strategy. So there's no conflict identified with any heritage policies there, is there?
No.
And there's no application of an analysis as to whether the heritage harm is outweighed by public benefits, is there?
In the planning statement, no.
But also notably, there's no mention, at least at that time, that you or Litchfields thought that S10 and BN5 were inconsistent with the MPPF. It's not there, is it?
No, it's not, no.
Let's move on then to the statement of case, so obviously a much more recent document, that's at K39. Page 30. And the heritage section runs from 7.80 on page 30 to 7.98 on page 32. Now, I can't find any identification within either that section or the document more generally on Litchfield's part that it was considered at this stage of the statement of case that there was any inconsistency between the relevant heritage policies for the determination of the appeal and the MPPF, or that there was any conflict as between ENV6 and BN5, for example. Is that fair?
That's fair.
Yeah, okay, so this point, it's only emerged in your evidence, so what was the epiphany? What changed?
Well, during the course of the planning application, of course, the application hadn't been determined. We were of the opinion, having reviewed that position leading into submission, that there weren't really those matters between the parties. So there was no need to go to the level of forensic detail that we've had to go to, having received the council's decision notice. The statement of case, at that point in time, and I have to be absolutely honest, we hadn't gone to the level of forensic examination needed to prepare a proof of evidence. So, you know, if the suggestion here is, well, you're being unreasonable, I'm sorry, but that's the position we've put out in the proof of evidence.
Okay, so you're I think I'll paraphrase and you can tell me whether it's fair or not. You're saying that it just wasn't something that you'd considered until you got to drafting your evidence. Certainly wasn't something that had struck you up until that point, was it?
Well, to be fair, at the point in time, local plan number 2 didn't exist. It hadn't been adopted.
I appreciate
So we
that,
were,
but there was an emerging policy of which you must have been well aware given your experience in the EIP process. Is that fair?
yes,
Yeah. And the start of this point, as it emerged through the statement of common ground, wasn't a point about conflict between development plan policies, it was a point about consistency with the MPPF. Now, the MPPF has been the same in respect of public benefits since 2012 at least, hasn't it?
I'll completely agree with you that we didn't advance that evidence at that point in time.
Fine. Okay, now let's just take BN5 as an example. So let's look at it's page 121 to 122 of the core strategy. Are you there?
Yes.
So I don't think we need to look at it in any detail, but we can see designated heritage assets and their settings and landscapes will be conserved and enhanced. And then over the page, in order to secure and enhance the significance of the area's heritage assets and their settings and landscapes, development in areas of landscape sensitivity and or known historic or heritage significance will be required to sustain and enhance the heritage and landscape features which contribute to the character of the area, including conservation areas, etc., etc. So we're in agreement that the policy doesn't include a requirement to balance public benefits against less than substantial harm. There's no dispute about what the policy says. What that policy does not say, however, is that development will be refused where it does not sustain and enhance or conserve and enhance designated heritage assets, does it?
No.
It also doesn't say that a balancing exercise under paragraph 202 of the NPPF should not be carried out, does it?
No.
That policy doesn't preclude the carrying out of the balancing exercise under paragraph 202, does it?
It doesn't make it explicitly a requirement of policy, but no, it doesn't preclude it.
It omits reference to it, in
Yes.
effect. Okay, now let's think about some examples of situations where you might have conflicts as between different development plan policies. So one can imagine a situation where you have, say, a core strategy from 2015 that sets an affordable housing requirement of 30%. You then have a local plan in 2020 that sets an affordable housing requirement of 50%. That is a situation, isn't it, where you have policies that are in conflict with one another. It's not clear which one should be applied. Do you accept that?
If they are, well, were they adopted at different times? If they were, then there is a conflict between the policies, they're requiring different things. Then paragraph 35, as expressed through the MPPG, requires a resolution in accordance with the most recently adopted policy, is my understanding.
Yeah, but that is a situation where there's actual inconsistency or conflict, where you've got two policies about the same topic saying something that cannot be, you know, it's either 30% or it's 50%, it can't be both. Do you agree that?
Yes, but equally it would depend upon the nature of the evidence that underpinning that particular circumstance, the nature of the evidence that underpin those policies at that particular time. Could be viability-leading.
I mean, I'm not suggesting that you wouldn't apply the most up-to-date policy. That is what the statute tells you to do. I'm just trying to see if we can agree situations where there is a clear conflict. Now, let me just put another example to you. So, for example, you've got a neighbourhood plan from 2015. It sets a settlement boundary and it only supports housing development within that settlement boundary. You then have a later local plan. It allocates land for housing outside the settlement boundary. That is a situation of conflict between policies, isn't it?
Sorry, could you say that?
Yeah, of course. You've got a neighbourhood plan, it sets a settlement boundary. The policy says, effectively, housing development is only supported within the bounds of the settlement boundary. The inference is that anything outside of that settlement boundary is not in principle acceptable. You then have a subsequent local plan, say 5 years later, things have moved on, it allocates a housing site outside of the settlement boundary of the neighbourhood development area. You come forward as a developer with your proposal for that allocated site. You've got a policy in the neighbourhood plan that wouldn't support it and a policy in the local plan that does. That is a situation where you have two policies that are inconsistent with each other or in conflict with each other. Do you agree that?
Wouldn't one policy have replaced the other upon adoption?
Not necessarily.
Okay.
But whatever the reality is, assume I can. It's not my role to give evidence, but that's not been my experience. But just assume that's a situation. Do you agree that that's a situation where there's an obvious conflict?
Mum, it's possibly not the best example, but yeah, I can see where you're coming from.
Now, the conflict that you allege here is where you have the omission of a test in one policy and its inclusion in another policy. It's not a situation, is it, where the two policies are actually in proper conflict with one another? Do you accept that?
Well, one policy has a very specific cascade of assessment in terms of how you review the implications of a policy, its impacts, and then potentially resolve those impacts through an assessment of public benefits. The other omits that part.
Yeah.
They're not in true conflict, are they?
I don't see how you could use BN5 in the same way that you could use EV6 without reference to further guidance. Doesn't preclude it, but it's not helpful in that EV6 has a specific process to follow.
Okay, do you find BN5 unhelpful, but it's not a true conflict, is it? Back to my question.
It's not a true conflict, no.
Okay, meeting employment needs. Mr Robinson accepted yesterday that the council was on track to meet the jobs target in the joint core strategy of 28,500 by 2029. It's right, isn't there? There's no specific jobs target for Northampton specifically. Too many specifics.
No, it's a West Northamptonshire job target.
And there's no employment land target or requirement for either West Northamptonshire or Northampton, is there?
Sorry, specific?
Land target.
No,
You don't
no,
have
there
to
isn't, no.
deliver 100 hectares of this or that, do you? Good, okay. And in terms of the most recently adopted part of the development plan, local plan part 2, this site was put forward by your client as effectively an omission site during the EIP process, is that right?
Correct.
Yeah. And as is obvious, it wasn't allocated. Now, my understanding of the position is that beyond the employment allocations that the council put forward, it wasn't considered necessary by the inspectors for any further employment site allocations to be made in order to be on track to meet the jobs target. Is that fair?
Yes, although obviously EC3 was found necessary in terms of embodying an element of flexibility within the policy framework to accommodate growth.
Yeah, yeah. So if you've got a site and you want to promote it, you don't need to wait for the new joint local plan, do you? You can bring it forward now and.
Well, as long as the evidence is there to underpin that,
Yeah.
and the site is acceptable in terms of the other policy tests.
Yeah, there's no
within the
constraint.
development plan. Yeah.
There's no constraint, so it's not. There isn't any requirement to wait for the new joint local plan to be adopted in order for additional employment land to be released in West Northamptonshire. If you've got a site you think's good, there's a permissive development plan approach to windfall employment sites. That's right, isn't it?
I think there are caveats to that in terms of the scale of a particular site and the strategic implications that that may or may not have.
Okay, but this site, you wouldn't be suggesting that there's a strategic...
A scale of this size, then yes, I would suggest that it could come forward as a windfall site, obviously subject to compliance with other policies within the plan,
Yeah.
in accordance with EC3.
And we're not, this isn't a greenbelt authority, so there's not some fundamental constraint that might be preventing, for example, employment land coming forward. Okay. Now, just I think we've discussed the windfall policy and we've discussed the allocations policy EC2 in the local plan. Just the employment safeguarding policy, which is EC1. In your proof of evidence, Paris 7.16.
Yes.
You include an excerpt from the local plan policies map showing the extent of the safeguarded employment land, which includes, it's Brackmills and Lakeside, isn't it? And I got a hint that you were seeking to suggest that there was some policy implication for this site of being located next to a area of land that's safeguarded for employment land, but there's no policy support in the development plan, is there, for employment sites on land located next to safeguarded employment land? Correct?
The reason for the excerpt.
Just answer my question,
I'll answer
please,
your question.
and then tell me what it is.
Well, the reason why
Just answer my question, please, and then tell me what you want to say. Yes or no? Is there a policy in the plan that supports the delivery of new employment land on land next to, but not within, safeguarded employment sites?
Yes.
What is that policy?
S4.
Okay, well, let's go there.
Not explicitly,
So there is,
but
right.
look at the words.
I mean, I would find that difficult to believe in a context in which the safeguarded employment land wasn't safeguarded until some years after the adoption of the Joint Core Strategy, but do explain what you mean.
Well, the policy says it canters through development being met primarily within the existing urban area and at sustainable urban extensions within the Northampton related development area. But it also says additional development to meet Northampton's needs will be supported, but it does caveat that only if it meets the vision and objectives policies of the plan.
It's not, it doesn't say that land next to safeguarded employment land achieves some special status in planning terms, does it?
No, but it gives the use of the word primarily acknowledges that there may need to be additional development to meet Northampton's needs.
I mean, that's not an issue between us. That's
right.
what I'm trying to understand is the significance that you say the inspector should place, if any, on the fact that our site is next to a safeguarded employment site. I appreciate the council accepts it adjoins the principal urban area, but those are different. They may overlap, but those are different designations. So is there anything special, or is there anything that the inspector should take from the fact that the site is next to a safeguarded employment site under policy EC1 of the Northampton Local Plan Part 2?
There is a reason why the plan is in the document. However, if we don't want to go there in answer to your question, it's just a matter of fact that it is adjacent to that area.
There's no policy significance.
No.
Right, that's really what I'm getting at. Now, the South Northamptonshire Local Plan heritage policies, clearly the appeal site is located outside of the former South Northants boundary, yes?
Yes.
And we agree entirely that the South Northants plan does not constitute part of the development plan for the purposes of this appeal. If the inspector finds conflict with the South Northants heritage policies, the council is not saying that the proposal will be in conflict with the development plan for the appeal site. Do you understand?
Yes.
We can also agree, can't we, that 2 of the affected assets are located outside of Northampton and in South Northants under the old boundaries. There's no dispute between us that the inspector's got to assess the impact on those assets when determining the appeal.
In policy terms or national policy terms?
In national policy
terms,
under statutory provisions. We can agree, can't we, that the policies HE1, HE5 and HE6, they're all heritage policies. They seek to protect heritage assets located within the South Northants boundary. Correct?
Yep.
And in a context in which South Northamptonshire assets are in principle affected by the appeal proposal, it is appropriate, isn't it, for the inspector to consider those policies that seek to protect them as material considerations. Nothing more.
I don't agree.
Okay, I think we'll need to leave that one to the inspector. Just on policies applying or being considered in other authority areas, that might be the case in a cross-boundary planning application, mightn't it?
depends if the matters to which the cross-boundary element relates have a cross-boundary related impact.
Potentially, but it may be, you may have a road that's required on one side of the boundary that needs to be delivered by something on the other side of the boundary.
Yeah, but it's linked
Yeah, okay.
between the two. I'm not saying, I mean, look, I completely agree that they are material considerations in terms of the heritage assets that need to be taken into account. I'm not sure the policy point particularly helps the inspector. I think they are material considerations, and we're all agreement to that fact.
Fine, okay, I won't take that any further. Identifying land beyond 2029, powers 6.58 and 6.59 of your proof.
So 6 point.
58 on page 32.
Yep.
And you might want to also have the MPPF up.
Yes.
Just bear with me. Yep, so you say paragraph 22 of the MPPF requires that strategic policies should look ahead over a minimum 15-year period from adoption in order to address the strategic priorities. Para 23 requires that land use designation and allocations are identified for bringing sufficient land forward at a rate to address need. And then you talk about what you perceive to be the delay to the West Northamptonshire local plan, and you identify what you see as a tension between the current policy framework and the need to identify land beyond 2029. Now we can see para 22 of the MPPF, says, as you've set out in your proof, strategic policies should look ahead over a minimum 15-year period from adoption. The Joint Core Strategy was adopted in 2014, wasn't it?
Yes.
And the policies within that plan run up to 2029, don't they?
Yep.
And the jobs target, for example, runs up to 2029, correct?
Yes.
So that plan did look over a 15-year period from adoption, correct?
Correct.
And we're not at the end of that 15-year period, are we?
Correct.
So there isn't, in fact, at the moment, any tension between the current development plan policy framework in West Northants and paragraph 22 of the MPPF. We're not in a world where there isn't strategic policies looking ahead over a minimum 15-year period from adoption.
And, you know, I'll give you that the plan has also been...
Just answer my question first and then...
No.
Did you want to say something else?
I was just going to say that it's inevitable, Ma'am, as the plan moves towards the end of that plan period, that the availability of land that was envisaged to meet the needs towards the end of the plan period will become pressurised where an authority has been successful in delivering its strategic objectives with regards to growth. So my reference to tension here is more to the point that whilst the plan is up to date by virtue of the fact that it was reviewed in June 2020, it was also the point that the plan sets out that there was an intention to review that plan, sets out at paragraph 3.17, and have an adopted plan in place by 2020. That's nearly 4 years ago. The plan hasn't been reviewed. That's where the tension exists, in that the practical fact of the matter is that it's inevitable that employment land or housing land availability for that matter will start to become more pressurised where market forces seek to demand or seek to continue with the supply of land. That's not to say the policy is out of date or anything of that matter. I'm not saying that. I'm just saying that the fact of the matter is.
Well, I think that needs to be put into context, doesn't it? I mean, we know that there's a permissive policy, EC3, for
Yep.
windfall development. So if the market wants to bring forward suitable employment land, the development plan is not providing a constraint to that, is it?
There is a mechanism, yes.
Okay. Policy R2, this is the best and most versatile agricultural land policy. Now you attribute moderate negative weight in the planning balance to the loss of some of that land from the appeal site, but you don't accept any policy conflict with R2. I just want to have a look at that.
Yeah.
We're going to go back to the planning statement, A2. Paragraphs 5.121. It's on page 31. 5.121, the Agricultural Land Quality Survey responds to the requirements of the following policies. Policy R2. 5.12, it says land of 5.122 recognises that the land is of grade 2 quality. And then at 5.123, given the majority of land is grade 2, it's considered that the proposed development would not give rise to an unnecessary loss of best and most versatile land and would therefore accord with policy R2. There appears to have been a lack of understanding about whether or not grade 2 is BMV at that point. Is that fair? Or at least that's how I've read that.
Ma'am, that's what we said at that point in time. I'll take that one on the chin. That's not what we're
Okay.
that is most definitely not what we are saying now.
Yeah, okay, fine. And it wasn't suggested at that point that policy R2 is irrelevant to the determination of the application, is it?
No.
Let's look at the statement of case. K39.
Yep, it's not in there either.
No, it is in there. It's just not what you're saying now. Statement of case, page 25. Para 7.38. Recognition that there will be a loss of BMV land, but then it will be demonstrated that the proposals accord with policy R2 of the core strategy. So at that point you weren't saying that the policy is irrelevant, you were just saying that you were in accordance with it, correct?
Well, we forensically examined the policy and put our best case forward.
Sorry, just help me with the answer first of all.
At that point in time, no, we won't.
And then what would you like to follow up with?
Having examined the case further, we have brought forward what we believe is to be the best case for the client based upon the facts.
The best case for the client.
To
But you understand that policy interpretation is a matter of law, so it's not a question of putting forward your best case. It's
I've
about
put forward
presenting-
my professional opinion in respect of the position of the proposal with regard to policy S2, sorry, policy R2, not S2.
Okay.
And you know, my view, having examined that policy wording, is that actually I think we're struggling to see how that policy could be relevant.
Okay, well let's have a look at it.
Yeah.
Page 203 of the Joint Core Strategy. Now I think your point is that you don't think that policy R2 could apply to the Northampton related development area because there are other policies within the Joint Core Strategy that support development to meet Northampton's needs within the Northampton related development area, correct? Is that about the...
Well, both policies
Just answer my question first.
Sorry, ask the question again.
So I'm just trying to make sure I've understood why you say that policy R2 is not relevant for the inspector to consider. And my understanding from your proof of evidence is that you say that because the site falls within the Northampton related development area, and you identify in policy S4 that it supports development to meet Northampton's needs within the NRDA, so long as they're consistent with other policies in the plan.
I think the policy relates to the
Just answer my question.
to the land area, yes.
Just answer my question first of all. I'm just trying to understand why you now say that R2 isn't relevant.
Sorry, could you ask the question?
Yeah, so my understanding from your proof of evidence is that you say that policy R2 is not relevant to the inspector's determination of the appeal. It simply doesn't apply because the site is located within the Northampton related development boundary, and you think that for that reason, because policy S4 supports development to meet Northampton's needs within the Northampton related development boundary, you think that this rural policy just isn't relevant?
No, that's not what.
Okay, well you tell me why
I'm
then.
saying. So what we're saying is that the policy R2. Well, I think first of all the site is within. If we go to R1, the site is located within the rural area. It's outside of the urban area. So policy R1 applies. Policy R2 relates to rural related development. It's not it doesn't support proposals. It doesn't specifically refer to proposals. It doesn't say whether proposals to meet the needs of Northampton are acceptable or not acceptable. It's a policy that seeks to deliver a specific form of development within the rural area. That's not what this current proposal is.
Okay, so you accept that policy R1 would apply to the appeal site in principle. Let's just look at the section of the plan where these R policies fall under is entitled Rural Areas, page 203. The introduction at 16.2. Whilst much of the JCS focuses necessarily on the challenges facing the growth and regeneration of urban areas, it also recognises there are key issues in rural areas. And then, sorry, the paragraph before that, the last sentence of the paragraph before that. For the purposes of this section of the JCS, the rural areas are defined as those areas outside the urban areas of Northampton, Daventry, Brackley and Toaster. Yep. So this is the appeal site in falling outside the urban area of Northampton, but within the Northampton related development area, it is expressly included within the rural area policies of the plan, correct?
Well, that's what I've said at 7.101 of the proof, yeah.
Sorry,
that's what I've said at 7.101 of my proof, because...
And there's nothing, is there, in section 16 or in policy R2 itself or in the supporting text to policy R2 which says that that policy does not apply to land located within the Northampton related development area, does it?
No.
No, okay. So the reason why you think it doesn't apply is because of something that isn't said within the plan itself, correct?
Well, the policy says proposals which sustain and enhance the rural economy by creating or safeguarding jobs. It goes on, lists a series of criteria. That's not what this proposal is.
Well, it's a site that's located within the rural area, so it may well support the rural economy in certain respects. It's not mutually inconsistent to be supporting Northampton's economy as well as the rural area, is it?
It's brought forward under the auspices of S4 and the NRDA.
Yeah.
It surely can't do both.
Okay, I don't think we can take that any further. I think the inspector, will have to determine that for himself based on what he's heard. I asked Mr. Drummond about trajectories yesterday and he wasn't able to assist in terms of when, if the appeal proposal is granted consent, when it might be expected that the development would actually meet the demand and need that's been identified. I just wonder if you can help with that. There's obviously a reserve matters application that would need to go in. There's certain conditions requiring, for example, contamination work to be undertaken, archaeological work to be undertaken, a written scheme of investigation, etc., etc. Do you have a view as to how long it would take to go through that process?
Well, I think the ES had talked about 2 years.
That's the construction phase, but you can't start the construction until you've got your reserve matters consent. So
that was it set out in 2020 outline planning permission, in 2022 full planning permission, actually 2024 completion. So the overall process from outline to construction was a period of 4 years, which assumed within that period 2 years of planning. That's what it set out within the.
Okay, so are you saying 4 years from now, or are you saying it should be a bit less than that because you've
But the reality is, with all this forward investment that the government has proposed with regards to speeding up the planning process, the RMA process should take 13 weeks, 16 weeks if we believe the planning.
Okay, but it's not just about that. You've got to do some work as well with the you've got to discharge the conditions in relation to. It's not just about timescales and local authority departments. So just is 4 years from now what you're saying, or are you saying it's a bit less than that? I'm just interested in when you think this might actually come on stream.
If we're talking about the planning process, much depends on the teams on both sides of the table actually, and I can give you examples of where a very large proposal took 16 weeks from submission to determination, and the conditions were discharged incredibly quickly. Depends on both teams on either side of the table.
Okay,
there are things called planning performance agreements, which if it is put in place and all parties want to see matters determined quickly, then it can happen a lot speedier than perhaps where we have a development team and a planning consultancy team that are at loggerheads with each other.
yeah.
A lot of that depends on the resources, obviously within the council team as well. Hopefully the announcements from the day will speed matters up.
I mean, what I'm just trying to understand is when you think. I appreciate what you're saying. I understand what you're saying, but when you think this might come on stream, ballpark, and that doesn't just take into account when a local planning authority is able to determine a reserve matters application. It takes into account when the developer thinks it's going to put forward that reserve matters application, when it thinks how long it thinks it's going to take for the work to be done to get that reserve matters application ready, the construction phase, how long it thinks that's going to last. Are you saying that that isn't something that's been thought of? I appreciate you've said 2 years for the construction phase, but are you saying that other than that you can't assist the inspector as to how long it will take for this to be built out?
If planning permission is achieved, then the progression of a reserve matters application, including details sufficient to avoid that there are a few pre-start conditions within the agreed list of conditions, but I'm sure that the developer involved, Duncan Group here, will look to ensure that a reserve matters application comes forward that deals with much of the matters that would potentially be subject to conditions, things like materials, things like detailed design, things like energy efficiency. All of that can be put in place by a design team as part of that reserve matters submission to avoid downstream wranglings with regard to conditions. I'm not going to say less than 2 years because that's what the ES says.
Okay. Sorry, just so I'm clear, do you mean less? You're not going to say less than 2 years before you get to construction?
No, I'm saying the matters will happen concurrently such that that time frame set out in the ES would be delivered. Obviously,
The 4-year time frame?
Well, obviously matters have prolonged because of the appeal process, but if we take that process away in terms of overall timescale, then that's what the ES says.
Yeah, I appreciate that. It's already 4 years since your application was submitted. So what I'm interested in is, it may be that you just don't know, but do you have an idea as to when, if permission is granted swiftly, when, say from January 2024, when do you think that the development might actually be opening up for new jobs and ready to go?
I don't have that
Don't know.
information.
Okay, fine. That's absolutely fine. Let's move on. Benefits. Can we look at your table, page 79 of the proof? Just dealing firstly with jobs now. You, this is on your 4-part scale. You attribute substantial weight to jobs, and Miss Ford, she was asked about whether or not she thought there was a difference of opinion between you and her, and she said she thought there was, that you'd attributed something more than what she'd attributed in terms of weight. The justification for applying substantial weight to jobs, as set out in your table, is policy 81 of the MPPF. It sets out that significant weight should be given. So you're saying it should be higher than the level of weight that the MPPF suggests. Is that right?
I've used a different scaling mechanism, and in hindsight, if myself and Ms Ford had agreed that mechanism, it would be one or the other. And I would be completely happy with a 3-stage or a 4-stage process.
But by using a 4-stage process, you're elevating the weight above Miss Ford, for example, to put it most simply.
Well, I've used, we've both given the weighting at the top of our relevant scales.
Yeah, but Miss Ford was asked about whether or not she thought there was a difference between you and her on jobs, and she said she did. So she thinks you're attributing more weight than her, and I'm asking you about that. Are you happy to say significant because you don't disagree with Miss Ford, or is there what is it that you're saying is this enhanced benefit associated with the delivery of jobs here that should attract substantial rather than significant weight?
Well, I'm saying it's the top of each of our scales in terms of what this is delivering that should give it that top of our respective scale assessment is one, the driver within national policy to secure economic growth, and two, the fact that as per the evidence from a commercial and employment perspective that we have an identified scenario whereby there is heightened demand for that floor space. That obviously also relates to the floor space dynamic of this.
Yeah, we're just on jobs at the moment.
But we're also in a scenario, the things are linked, we're also in a scenario here whereby the council hasn't yet met its jobs target. As I say, it may well do next year, it may not do. We don't know where the economy will turn. But in the context of that driver, I think we have to give the desire to create jobs and deliver that economic growth with the highest level of weight that we can within the respective scales that we've chosen.
Okay, and I mean, would you be saying that if the proposal was going to deliver 10 jobs?
No.
No. So there has to be some level of differentiation based on the scale of the jobs offered. Yeah. Okay.
Same way the benefit we would give to delivery of housing.
Okay, I don't think we can take that any further. The capital spending, you've given that substantial weight, so absolutely the top category. I'd like to look at the environmental statement again, because when you were asked about this by Mr. Goatley, he said, well, it said that the evaluation is only a small proportion of what would happen in the economy more generally. And you said, yes, it has to be in the wider economy. That's what's in the ES. Now, I just want to look at what, in fact, is in the ES. CD, it's A 3.5. Are you there?
Yes.
Page 1 of that document at the bottom talks about the areas of impact. We looked at this yesterday. 5.2.3 over the page sets out exactly what the analysis covers, and it's not the wider economy, it's Northampton as the local impact area and West Northamptonshire as the wider impact area. Do you see that?
So 5.2.
2.3.
Yes.
And then you go down to 5.2.8. That's under a heading significance criteria. And first of all, at 5.2.7, it tells you what's meant by beneficial, negligible, adverse. Beneficial, a positive and or advantageous effect to a minor, moderate or major magnitude. And then we get down to 5.2.8, the table there. And the relevant one for us is minor significance of effect, where the proposed development could be expected to result in a small, very short or highly localised effect on the existing population, level, type of employment, level of deprivation and economic characteristics of the area. And this will be familiar because we looked at it yesterday. If you go right down to the bottom of the document, we can see that your colleagues at Litchfield's assessed this scheme to deliver only minor beneficial effects in terms of economic output and the economic impact on the labour market, can't we? And that was at a Northampton and West Northamptonshire scale. Do you see that?
5.6.3.
Yeah. Did you review this chapter before you came to a judgment about the weight to be attributed to benefits of, for example, capital spending?
Yes.
You did, but you didn't express any disagreement with it in your proof of evidence. So can I take it that you accept this analysis?
Well, of course I do. Accept the analysis within the yes. Doesn't mean I necessarily accept.
Mr. Kirby, could you speak up a bit? So I'm losing you sometimes.
Sorry, the microphone had gone off. Yes, of course I accept the outcome from the environmental statement. That doesn't necessarily mean I accept the benefits to be accrued to that in terms of weighing up what this development would achieve in terms of that contribution towards the local economy.
Okay, well, again, I don't think we can take that any further. We'll have to leave that with the inspector. In terms of the delivery of needed employment land, you've attributed that substantial weight, and I just wanted to make sure we've put that into its proper context. So in terms of the need identified, or the shortfall of industrial land identified in the 2021 HINA for Northampton, that was 23.2 hectares, wasn't it?
Yep.
And those 23.2 hectares, according to that HINA, which assessed a 30-year period from 2020 to 2050, it was saying that those 23.2 hectares would be needed over that 30-year period. It wasn't saying that 23.2 hectares are required today. Do you understand that?
Yeah.
And so, taking that figure, we'd be looking at less than a hectare a year for Northampton in terms of the required delivery of additional industrial land, correct?
Sorry, I was just looking for the planning committee report actually, just to remind myself what was said.
Yeah, do you want to look at that? It's K1, isn't it?
Thank you.
You might want to look at 8.28.
Yep.
That identifies the shortfall of 47 hectares of B2B8 over the period 2020 to 2050. That's the West Northants figure from the 2021 HINA. Was there anything you wanted to point out in the officer's report?
No, that's exactly where I was going to in terms of that paragraph.
Yep, so even if we're looking at the West Northants figure, it would be 1.5 hectares a year over the 30-year period, something like that. Do you see that?
Well, if you extrapolated it over that period, then yes, but the evidence is that demand for the space is there now.
I appreciate that. Demand is different from need. There may be an interaction between the two, but demand is different from need. You've led evidence on both of those matters. Now, Mr. Robinson's evidence was that the need or the shortfall was potentially much greater than the 23.2 hectares or the 47 hectares for West Northants. But even still, his assessment was looking ahead over a 30-year period as well, wasn't it?
Yes.
Yeah. So when the inspector's considering the weight to attribute to the delivery of additional employment land, which it's accepted is needed, he will need to bear in mind that those assessments all forecast over a 30-year period. It's not the next 5 years, for example.
I don't think you can look at that in isolation. I think you need to also bear in mind and look at how that relates to the vision objectives of the plan in terms of achieving economic growth.
Mr. Kirby, just help me a bit. Can you just say whether or not you agree with the point that was made?
Yes.
And then clarify it. That would be useful. Thanks.
Okay. Yep. I think I've probably done both in reverse order.
And then in relation to the demand point, we heard from Mr. Drummond yesterday that the levels of demand in the Northampton area are not out of step with levels of demand across the country, and also that the rents are not out of step with levels of demand, with levels of rent across the country. That levels of rent are high here, but they're high elsewhere. Levels of demand are high here, but they're high elsewhere. So again, do you agree or do you accept that that's something that the inspector will need to bear in mind or take into account when he's considering the weight to be attributed to the delivery of additional employment land here?
Yes.
Yeah. Highway improvements, it's agreed that it's a benefit. Miss Ford says limited weight, you say moderate weight. You referred in your evidence in chief to the provision of the footpath and cycleway associated with the development. How long is that cycleway? What's the length of it? Or what area does it cover in broad terms?
I think we could probably benefit ourselves by drawing up the highway related improvement plans to explain that one.
Is it H3 you want to look at?
I think so, yes. It's not going to give a dimension. I can give you the width, I can't give you the length. What it does do is provide a continuous route along the southern side of Bedford Road.
Yeah, but where does that go to? Is it just the turning onto the High Street in Great Houghton?
Yes.
Yeah, okay. So for the inspector to judge the weight to be attached to that benefit, he does of course need to understand what the scale is of that cycle path. So it's running from Bedford Road as it meets the High Street to towards the Lakeside roundabout.
That's right, yes.
Yeah, okay. Now, just so we're clear about the harms that you've identified, you accept moderate weight to the loss of best and most versatile agricultural land, correct?
Correct.
You also accept heritage harm, and we'll come on to that in a moment. And in the event that the inspector accepts the council's case, as in the council's case wholesale, there would be landscape harm in the balance as well, wouldn't there?
If he accepts the council's case, yes, absolutely.
Okay.
heritage policy compliance and the balance. So the policies of the development plan that we've discussed that
I'm sorry to
require-
interrupt. It's get on to 3. I would normally have a break now. Is it worth carrying on?
Yeah.
Okay, in
got
that
one page
case.
left.
I thought that might be the case, but thank you.
And I mean, I'm very happy to have a break, but I'm fine to carry on if Mr. Kirby is as
Mr.
well.
Kirby,
You are.
you're the one answering the questions. Are you happy to carry on?
Absolutely.
Thank you.
Okay, so on the heritage policies now, the policies of the plan that require assets to, for example, be conserved or sustained or enhanced, but don't include a requirement to balance harm against public benefits. Your case is there is some heritage harm, so on your case you must accept that there is conflict with those policies. So
BN5, S10, etc.
The policies need to be read in the round. So it's got the policies need to be read in the round. So yes, I would agree with you, but then you need to look at ENV 6.
not denying,
Okay,
I'm not denying
yeah.
that. But on your case, you do accept that there is development plan conflict with BN5, S10, Q1, insofar as they relate to heritage matters.
I think I have to caveat that answer to the para 35 point.
Okay, but you've accepted that there isn't a true conflict between those policies and ENV6 and the MPPF, so I'm not sure where that point's now going to go for you.
Well, there is a conflict between them.
Well,
It's not a black and white conflict,
Right,
but they say
okay.
different things.
okay. Now, so there's some conflict. There's conflict with some of those policies. There's then a paragraph 202 balance to be undertaken, or the balance within ENV6. Well, both in effect. Your proof of evidence. I think we need to look at your addendum now. Can we look at page 78 of your proof of evidence and the addendum? So just have both open, please. Now, when your proof was written, there was acceptance by your heritage witness that there was less than substantial harm to Great Houghton Conservation Area, so you were obviously applying the heritage balance. I can't see in section 8 of your proof of evidence the assessment that you made at that stage of the weight to be attributed to the harm to Great Houghton Conservation Area. Did you attribute weight to the harm? Or what weight did you attribute to the harm, perhaps more clearly?
Looking at the proof, I'd probably say at that point I hadn't.
Okay, you hadn't. And now that you've heard Mr. Borden's concessions, you've updated your position and you have attributed negligible weight to the harm to the 4 designated heritage assets. Now, negligible weight is the lowest within your spectrum. So it's negligible in relation to 4. In relation to 1, it must have been negligible as well. There wasn't anywhere lower to go, according to your scale. Yeah.
Yep.
Okay. And the inspector can note, can't he, that you've attributed moderate negative weight to the loss of some best and most versatile agricultural land, and he'll need to consider the credibility of your position in relation to weight as regards harm to heritage assets in circumstances in which you attribute lesser weight to the heritage harm. That's a comparison that he'll need to make, isn't it?
That's correct.
You accept, don't you, paragraph 199 of the MPPF that great weight needs to be attributed to the conservation of designated heritage assets? Yep.
Yep.
You also accept, don't you, that the more important the asset, the greater the weight should be. So if there's harm in principle to a grade 2 star listed building, then that should be accorded greater weight than, say, a grade 2 listed building for the same level of harm, for example.
Yeah,
Yeah.
I totally accept that. That's why I've included Mr. Partington's evidence and used that to suggest that if the inspector were to take that view, then my position would move to one of moderate.
So that's a different point.
Okay.
That's about the level of harm.
I agree.
This is about the importance of the asset. So here we're dealing with 2 star listed
Yep.
buildings. So the more important the asset, the greater the weight should be. You agree that?
Yep.
Okay. Because we have harm identified in relation to 2 listed buildings, the section 66 statutory duty applies. You don't disagree with that, do you? And that means that the inspector will need to attribute considerable importance and weight to the heritage harm, correct?
Yes.
And there's a strong presumption against the grant of planning permission that would harm listed buildings, correct?
Yes.
Yeah, okay. Just in relation to the table that you've produced in your addendum, where you've sought to set out the effectively where Mr. Bourne's evidence ended up. In relation to the Little Houghton Conservation Area, in the proof you said no effect, and in relation to the Church of St Mary the Virgin you've said proof no harm. Is that, do you mean the same, do you mean those to say different things, or is that a typo?
I hope we reflected the words that were in, that we'd taken from the evidence, but maybe there is a typo there. Perhaps you'll correct me on that one.
I'm not sure it makes much difference. I just wanted to understand whether there was some significance to what you were saying there. Okay,
No significance, Mum.
And just in relation to this table, I understand why you've produced this table, but the inspector will need to be careful, won't he, not to look at this table in isolation, because the reasons why less than substantial harm has been found by the various heritage professionals who've been involved in this application and appeal has differed. So, for example, Mr. Partington finds harm to the Great Houghton Conservation Area on a number of different bases. Mr. Bourne's basis, maybe, or perhaps a better example, is in relation to the Little Houghton Conservation Area, where Mr. Partington identifies harm arising from views out from the conservation area as well as views in, whereas Mr. Bourne's concession related only to views in. So you're not inviting the inspector to look at this table in isolation, are you? He's got to also look at the basis for the different views that were taken.
Yes, of course. I mean, what I tried to do is to reflect the level of harm that had been identified by the 2 parties in the ES. And in 2 of those, it was at the lower end of scale. On 2 of those, there's a difference, lower end of substantial harm, at the less than substantial harm at the lower end of that scale. And on 2 of those, there's a disagreement where I think Rob Bourne was at the lower end of that scale and Adam Partington was towards the middle of that scale. Either way, it's less than substantial harm. So that's why I'd said, well, it needs to reflect that in terms of the overall balance.
Yeah, okay. And in your evidence in chief, you said, well, you were asked about the attribution of weight to heritage harm, and you said, well, if we weren't in the category of less than substantial, you think it would be a different ballpark. So are you saying you would only attribute significant weight to heritage harm if that harm constituted substantial harm?
No.
Thank you very much. I don't have any further questions for you.
Thank you. Mr. Goatley,
I do have going?
I'm happy to keep going. I'm just looking at everybody else in the room. So Mr. Kirby's happy, Mr. Daly's happy to keep going. I think they're the main actors at the moment. So if
Fine. I'm happy to keep going. Mr. Kirby, you were asked regarding succession of policies which are in the JCS or local plan part 2, and whether or not there is some form of tension or otherwise. ENV6, Q1, BN5, and I think S10. Are they all saying the same thing?
From a heritage or landscape perspective, or both?
Heritage, first of all.
Okay, from a heritage perspective, there are differences between the policies. If we focused on ENV6, for example, it has a specific cascade of understanding the asset, assessing how a scheme could relate to it, followed by an assessment of whether or not there is a justification via qualification with regard to public benefits. That doesn't exist within the other policy matters, be it Q1, BN5 or S10, specifically with regard to the heritage-related criteria to which applying those policies.
Okay, in respect of those policies, Q1, S10, BN5, recognise they come from different plans. Taking each of them in turn, which are directed specifically to the issue of heritage matters and heritage protection?
So if we start from BN5, just trying to draw out the...
K11, I think.
Sorry, 111.
I think it's K11.
Okay, so I've got the policy up.
I beg your pardon, thank you.
Which page is it on?
The page in terms of internal numbering is 121.
Yep.
Or 31 of 49 if it's the PDF.
So if we start with BN5, I think the point was made to me that it doesn't say you don't have to consider public benefits, which is very true, but the policy equally is not specific in respect of that matter. There is a conflict between the requirements over what is needed to be assessed against each policy. So I think the point was made, is it a true tension? I think maybe I had misunderstood, taken those words as meaning something perhaps slightly different to the way in which they were intended. I have to say I think there is a conflict between the requirements of what needs to be assessed in respect of BN5 and ENV6, and I'll maintain that point in coming back to that topic area to respond to your question.
If a decision taker faced with BN5, would a decision taker be operating incorrectly in accordance with BN5 if the decision taker failed to carry out a balance? If it doesn't carry out a balance, is he doing the right thing or the wrong thing?
In terms of looking at the development plan as a whole, he'd be doing the wrong thing.
Yeah, but what about BN5? Just BN5. If he carried out no balance, would he be conflicting with anything in BN5?
Yeah, para 202.
Sorry?
Para 202 of the MPPF.
Of the MPPF, but what about BN5 itself? If we just looked at BN5 and carried out no balance, would that be in accord with that policy as an approach, or would that be
in conflict with that policy as an approach?
The policy does use the words and justified. However, it's not specifically seeking to apply that balance. So you would be... Sorry, what was the question again?
Yeah. If a decision taker utilising and applying BN5 for the purposes of assessing a proposal that has an impact or potential impact on heritage assets, if that decision taker did not carry out a balancing exercise, would that be in conflict with any of the requirements within BN5?
It would be in accordance with the requirements of BN5. Sorry, it would be in conflict with BN5.
What would be the conflict with BN5?
Sorry, I think I've got the question the wrong way around.
Right. Just take a moment.
If the decision maker didn't apply a public balance exercise, he would be determining in accordance with BN5.
Thank you. Would a decision taker be in the same position in applying ENV6?
No, if he didn't apply the public benefit test, he'd be in conflict with the policy, which is where the tension lies.
What about Q1?
As far as the specific heritage criteria is concerned, it'd be the same answer.
And with regard to S10?
Same answer.
Now, you came back to the issue on conflict when my learned friend asked a further question as to whether there was conflict. And your answer to that was that there is a conflict because they say different things. As far as they're saying different things, your view, please, what are those different things requiring of a decision taker?
The different things is that one is requiring an assessment of public benefits to determine whether or not harm to the heritage asset is justified, whereas the others are not.
Now, you've given two views to my learned friend as to conflict and true conflict. For the purposes of understanding the position clearly, can you please explain whether you think there is or is not a conflict between the policies and the basis for that?
Well, I think as I've set out in this proof, and perhaps not responded maybe as clearly as I could have done, my view is that there is a conflict between ENV6 and BN5 in that one requires the decision taker to take into account the analysis of any potential adverse impact and to weigh that against the public benefits that may arise from a development. That test is in ENV6, it's not in BN5. And a similar response would go for S10 and Q1, where that policy relates to heritage matters. I think that's the conflict within the policy text.
Thank you. That's on the heritage side. The landscape side.
There isn't a public benefits test specifically within the NPPF in respect of landscape matters. So I'm not sure we would arrive at the same position. However, clearly from a landscape perspective, the scheme needs to be assessed against its individual merits which was undertaken by Tim Jackson through his response to evidence.
Thank you very much. Yes, it's an aside. It's in respect of the South Northants matter, those policies. One question that was put to you about a cross-boundary proposal. Explain, if you would, briefly, a cross-boundary proposal, and if his proposal is cross-boundary, which, if any, development plans would be involved?
If it's cross-boundary, it would be both local planning authorities, unless one planning authority had divested its responsibilities as a planning authority through the Local Government Act. I've forgotten the specific provision to the other authority.
Would that be a direct parallel to the circumstance here?
No.
You were asked regarding employment need and whether the need was 1 hectare per year going forward or 1.5 hectares per year going forward, depending upon whatever view was taken of some of the council's evidence. With regard to Mr. Robinson's evidence, does that suggest that the need is perhaps 1 hectare or 1.5 hectares per year going forward for the next 30 years?
No, it doesn't, and I'm not sure that's expressed anywhere else in that format either.
In terms of Mr. Robinson's assessment of need and the quantum of that need, has that been contested or contradicted by any evidence of the LPA?
No.
With regard to Mr. Drummond's identification of market signals and market demand, has any of that been the subject of contradictory evidence from the LPA?
No, sir.
Your view, please, having heard the evidence, Mr. Robinson and Mr. Drummond, is the identification of the issues relating to Northampton just the same as the issues of anywhere else in the country?
They're specific to Northampton. They may be repeated elsewhere, but the assessment is specific to the locality upon which it's been based.
Thank you. You answered one of Belinda Friend's questions relating to some of the development plan policies, as the policies need to be read in the round. What do you understand to be the statutory and national policy approach to dealing with the development plan and the consideration of a proposal by reference to a development plan?
Exactly that. The development plan should be read as a whole, not just the disparate parts of that development plan. That means applying the relevant policies as well as taking into account any conflicts that may arise with regard to the specific guidance under the MPBG and Para 35. Section 35 even.
Thank you. You asked about the application of the statutory tests with regard to listed buildings, section 66. The section 66 tests, which you readily acknowledged, matters the inspector needs to take account of. Your view, does that alter any of the assessments or judgments that you have made?
No, I don't believe it does, given the low level of impact that we are referring to against all of the witnesses' stated positions and that of the environmental statement.
Mr. Kirby, thank you very much. Thank you, sir.
Thank you, Mr. Goatley. We've, I think, now reached the end of the evidence part of the inquiry. As we've already dealt with the Section 106 and the planning obligation, and we've also are doing closings next week, there's probably only one matter that we need to deal with this afternoon, and that is that relates to costs. Again, I'm not inviting any applications for costs, but are there any applications for costs, Mr. Coatley? No. Okay. In that case, there just one final thing. Is there anything else that anybody would like to say, or that they've missed, that they would like to include at this stage?
So there's just one very small point, which is, do you recall yesterday I identified one of the conditions had a typo in it?
Yes.
The council and the appellant have now slightly reworded that,
That's fine.
but it's agreed between the parties.
If that can be sent to the case officer, that would be useful. Thank you. Mr. Goatley, is there anything from the appellant side?
Sir, no, just nuts and bolts for our virtual hearing next week. So conventional position is obviously we won't be exchanging closing submissions. We'll obviously send closing submissions to the planning inspectorate and then look to dispatch those to the other side. What I was going to suggest, my learned friend and I, just make sure that we have our requisite email addresses so that we have them, so that you have them in time to look at them, and vice versa.
Yes, I think if I can get the written copies of the closing submissions by, say, 9 o'clock on the morning of the closings, that would be fine by me. Just a question of making sure you get them to the case officer fairly early, so they do get them.
Is that Alison Dyson?
It is
Yeah,
Alison Dyson, yeah.
fine. Yeah,
Yeah,
that's right. I've
that's
got her
right,
email
yeah.
address. Thank you, sir.
Yeah, so that's what I would say. Other than that, then all remains for me to say is thank you very much for this week. Everything's been very polite, which is always useful. So I'd like to wish everybody a safe trip home, and I will now close the inquiry until the 30th of November at 11 o'clock, which we will be doing virtually, and the council will send me a link for that, won't they? Thank you for the case officer. Thank you very much.
Thank you, sir.
Thank you, sir.
Is there some trolley?
Yeah, yeah.
I've tried to park near the door down there, so...
I can go straight down the lift as well.